Okay, first order of business will be the appeal 2018-36, Gladding Shops LLC, Rocket Real Estate LLC, Federal Properties of Rhode Island Incorporated, 11 State Street LLC, and New Leaf Realty LLC.
Mr. Chairman, I'd like to ask our solicitor for some guidance before we get this matter started with respect to standard of review. So I looked at the code, section 28-408I, and that indicates.
I can clarify that for you.
Okay. And it talks about clear error or clearly exceeding authority. So could the solicitor explain to the board what does that mean?
As you know, we have two hearings tonight, one appeal from the Planning Board, one appeal from the Historic District Commission. With this board, the Zoning Board of Appeals acting as, Zoning Board of Review acting as the Board of Appeals in each case. In both cases, the same standard of appeal applies. It's made, I think, more clear in the state law, which is controlling, because both the planning ordinance and the Historic District Commission ordinance are based upon comprehensive laws that have been passed by the state. So their review standard has to be consistent with the state law. And that language is that, quote, the Board of Appeal shall not reverse a decision of the Planning Board or Administrative Officer, or also in this case, the Historic District Commission, except on a finding of, number one, prejudicial procedural error, or number two, clear error, or number three, lack of support by the weight of the evidence in the record, period, close quote. I'll note that I added the numbers for our own clarity. So that's the standard by which you're guided. Prejudicial procedural error. And again, it's procedural error, but if the procedural error didn't make any difference and wasn't prejudicial to the case or against a party in the decision, then it's not of matter. So it has to be prejudicial procedural error. Clear error, or lack of support by the weight of the evidence in the record, which also means that it's not for this board to make findings of fact. This board will accept the findings of fact from the board below unless it believes that the board below had no evidence to support the decision, no factual evidence to support the decision that it made. So that is the standard of review. We're not taking more evidence tonight. There are no new witnesses. It's not here for comment concerning any issues other than those specific issues which have been designated in the written appeal documents that have been filed in this case. So we're here for a very narrow purpose, and your review and your decision has a very narrow focus. The public will be entitled to comment, but again, those comments, this isn't like the big hearing that was at the elementary school where all sorts of things could be brought up. We're here to discuss only those issues of appeal and how they may have constituted prejudicial procedural error, clear error, or lack of support by the weight of the evidence.
I have a couple of questions, Mr. Haddon. if you
Sure.
don't mind. So the first question I have has to do with,
Could you speak into the microphone, please?
first question, I don't know if it's on. Is it on? Okay. First question I have to do has to do with the comment you made about our procedure in terms of who gets to speak at this,
Sure.
appeal.
So the procedures in the Board of Review's procedural document clearly indicates that the appellant, as is usual in an oral argument in a court, the appellant will present his or her case first, designating those points that the appellant believes violated that standard of review. So it would be for the appellant to present to the board what was the prejudicial procedural error, what was the clear error, or what was the lack of support by the weight of the evidence in the record. And the board is free to ask questions of counsel at that time, should it wish to do it that way, or to then proceed to those in favor of sustaining the decision below, who will then argue whether they're, in this case you'll have the applicant, and then you also have counsel to the Historic District Commission and to the Planning Board, each of which may itself have a designated member under your rules of procedure. And those designated members may comment concerning the appeal, and or their counsel may comment and argue as well, most likely pointed towards those elements that the appellant has brought before you. So it might be best to have the appellant go through the entirety of what he believes will sustain his appeal, and then have those in opposition to it focus their arguments in opposition to that. So perhaps what is more disputed and what is less disputed can be of a better focus. And then the board may wish to question each side at that point, or say, we just want to talk about issue A. So you ask each one on issue A, clarify for me this or that or the other thing.
So, Mr. Haddon,
Yes.
sorry to ask lots of questions, but
That's okay, that's what we're here for.
we do this correctly. So, as I understood it, you said that we will hear from the appellant, from the objectors, and the appellant, and then the appellant is the objectors, and then the developer, and then counsel or perhaps a designated representative from each of the boards or commissions involved.
Right.
So would that be one counsel argument and one designated representative argument, comment, whatever? So it's counsel and a representative can speak? You said and or.
I think it's and or, because that seems to me the way I interpret your rules of procedure.
Okay.
And if Mr. Tights intends to speak for everyone in one
Mr.
way,
Tights is not our
that's
solicitor.
fine.
I'm looking for advice from our solicitor.
No, that's not what I was saying. What I said, that if Mr. Tights were to choose, after agreement with his clients, that only he would speak for them, that's fine too. They don't have to speak.
I understand that.
But the rules of procedure would permit that, I think.
Right, but it would be counsel and one designated representative from the planning board, one designated representative from the Historic District Commission.
Correct. However, my understanding of the rules are that if another member of the Historic District Commission or of the planning board would want to comment, not as the designated person as designated under the rules, but as a member of the public in general, since their decision is gone, there's not an issue with that. they're evidently free to do that.
And we also are expected to open it up for public comment, is that what you're saying?
Yes, public comment is allowed, but again, that public comment should be finally focused on the issues of the appeal, and I think if the folks would focus on exactly what has been brought forward by the attorneys and focus on what those disputes realistically are, that would be a best benefit. Rather, we're not here to reopen the record, we're not taking any evidence, we're not adding any more statements, there's no more pictures or diagrams or anything like that. The record is the record, and we go from there.
I have one last question, Mr. Haddon. The three bases for reversal, prejudicial, procedural error, clear error, lack of support by the weight of the evidence in the record. Clear error, is there some better understanding of what that means that the board could use? Or is that just, I know it when I see it?
Yeah, I think the latter definition is probably as good as you'll realistically and practically get. But I also think that if there's a law that says A and the board has perhaps completely ignored it or hasn't even commented on it, and there's no support in the record for that proposition, that could be clear error. And again, the parties themselves will attempt to apply their argument to the standard of review such that they will claim that thus and such is this or that, or satisfies the standard of review in this way or that way.
Thank you.
So you'll also hear argument by them as to what those terms mean.
Mr. Chairman, may I just raise two procedural items? Yes. Andrew Tights, T as in Thomas, E-I-T-Z, Assistant Town Solicitor for the town of Bristol, and actually that's my first procedural matter here, is I am representing both the Bristol Planning Board appellee and the Historic District Commission appellee. And I just want to confirm for the record that Mr. Tanner, as your secretary, has received written confirmation from both of those bodies of that designation.
The chairman has both copies.
And just to make it easy for one of Mr. Cogan's questions is, I will be representing it. It won't be double testimony of me and the chair or someone, it will be me. So we'll keep it simple. Then the other question I just wanted to ask the board, sitting as a Board of Appeal, is whether you intend to do these as two separate and distinct hearings, one for the HDC and all the way through and vote, etc., and then one for the Planning Board, or since the standards of review are the same, do you intend to combine it as one hearing and then take separate decisions?
Well, from an efficiency standpoint, it might make sense, but given that one of the grounds for appeal is at the lower level, these matters were combined, whether rightly or wrongly, I think we should do them separately.
I agree.
It's going to be too confusing both ways.
That's fine. I just wanted, I admit I was one of the people involved with setting forth the notice, and we put the line in there to give you the option if you so decide. I just wanted to know something. And you intend to do which one first?
The HTC is first.
Okay. Thank you very much.
Members of the board, it's Steve McGilvery. On those procedural issues, I represent a group of objectors. As far as Mr. Tights representing the HDC and the Planning Board, I do have an objection to that. Mr. Tights did tell me he was going to do that some time ago. I've thought about it and talked to people, and I actually think there's a conflict there. You are basically his client day to day, and now he's asking you to take his word equally with mine and members of the public. And I think that is not only an actual conflict, but an appearance of a conflict. So I want to raise that as just a, if nothing else, to preserve that as an argument.
Sir, can you spell the last name, please?
Sure, it's M-A-C, capital G-I-L-L-I-V-R-A-Y. And just to follow the sign here, I'm from Pierce Atwood, which is at 1 Financial Plaza, Providence, Rhode Island.
Mr. Chairman, may I respond?
Sure.
I just want to note for the record, which I think is obvious, but maybe not, because as Mr. Cogan said, you are provided with, Mark Haddon is legal counsel to you tonight. He has no financial connection to me or any member of my firm. He's separately, independently hired by the town to provide you with the independent legal advice. I do not think it would make sense to have totally new counsel on both sides, and I think it would certainly be worse for me to be sitting over there. I can understand that would be inappropriate. So I just want that noted. Thank you.
And I would only add to my point there is, Mr. Tights has already said he took a hand in drafting the notice for this meeting. You're obviously very familiar with him. He is, in essence, your lawyer every day of the week, except for these, hopefully, hour or so that we'll spend together. Wait until I start talking to him. Anyway, so with that, I can start at the board's pleasure.
Sure.
Go ahead. So again, I'm Steve McGilvray. I represent the applicants or the appellants here, and I think the town solicitor's done a good job enumerating the standards that you have to follow. The question was, I think from one of the board members, what is clear error? I have used in the past, and I think this is pretty conventional definition. There is clear error when a decision or action appears to have been unquestionably erroneous. The Planning Commission's decision can be vacated because it is clearly erroneous when in view of reliable, probative, and substantive evidence contained in the whole record.
Excuse me, Mr. McElroy. It was my understanding we're starting first with the Historic District Commission appeal. So I just wanted to make sure, okay, you're aware of that.
Yep.
All right, because you just referenced the planning board issue, so I just wanted to make sure.
I'm sorry, a planning board or historic district commission, a lower administrative body can be
Sure.
overturned.
Okay, I just didn't
Well,
want
thank you
there
for
to be any
clarifying.
confusion. All right, thank
I
you.
appreciate it. Clear error could include a factual error or the application of an incorrect legal standard. So that's, I think, a little bit more meat on the bones of what clear error is. During my presentation tonight, I'm going to give you some reasons why we brought the appeal. I'm not going to go through every one of them that's in the application. You have our application. I'm going to highlight some of those for you. We're not waiving the others. We still stand by them. But just in the interest of time, I'm not going to go through each and every one. You've read them already. I'm going to guide you through the highlights. Errors in procedure. The first error in procedure that I'd like to just draw your attention to was voting on the basis of non-existent or future guidelines. In the findings of fact drafted by the town solicitor, it stated that, quote, the HDC notes that these guidelines, this is the HDC's guidelines, are 31 years old and in need of updating themselves. This is an inappropriate consideration. The present guidelines, there's just no question but that the present guidelines remain in full force and effect until they're replaced. For the HDC to somehow say, these have reached their point of expiration, according to us, we're not going to weigh them as heavily, which is in essence what they're saying in their decision, is inappropriate and is either a clear error of law or an error in procedure. The next point is really, I guess, the original sin of both these appeals, which is the unprecedented and inappropriate joint meeting between both the HDC and the planning board. It caused the HDC, and I'll talk about the planning board later, obviously, the HDC to avoid its own standards, as well as Secretary of Interior standards and the Bristol Comprehensive Plan. The joint meeting and how it was conducted represent a fundamental error procedure that tainted the entire deliberation and the voting process of both the planning board and the Historic District Commission. The town has on its website a flow chart. I won't make this an exhibit because we're not taking evidence, but you can take notice of it because it's your own document. And it shows a column for planning board review, various steps, and on the other side it shows the Historic District Commission, and those then independently feed into the zoning board. So they're meant to be two completely different deliberations, two different boards. They have different timelines, and most importantly, they have completely different standards. And what you saw, if you've read the record, is a confusion where during deliberations, these two boards talked to each other and said, I like this, no, I like this better, without any reference to their individual standards that are to guide them. So that was the, again, I call it the original sin. It's kind of what set this on the wrong track. And there's a number of errors that flow from that. One of which is that the decision of the HDC is, in essence, a fiction. Courts of Rhode Island have held that a court must review the decision and ensure that, so when a court looks at this at some point, ensure that the board members resolve the evidentiary conflicts, made the prerequisite factual determinations, and they applied the proper legal standings. Those findings must, of course, be factual rather than conclusion, and the application of legal principles must be something more than a recital of litany. And that's Gerard versus Zoning Board, the town of Barrington, a case from 2015. So,
Is there a citation?
yes, it's 2015 Westlaw 6829379 at 3. That's pretty black letter law in the state. I
Can you provide me, what was the name of that again, the first name?
Gerard.
Gerard.
G-I-R-A-R-D.
Is there a court?
It's the Superior Court.
Thank you.
And it was
versus
Zoning Board of the town of Barrington. But that's there's probably, I don't know, 15, 20 cases that say the same thing, that the board has to make its own findings and handle evidence and look at the evidence. Handle evidence, make evidentiary decisions when there's conflict, and make factual determinations. Here the HDC didn't do that. It didn't address, if you look at the transcript, it doesn't address most, if not all, of the required standards for approval. And it didn't address what later came out from the town solicitor's office as the findings of facts. In fact, the HDC's approval of the pitched roof design, which were the plans of April 17, 2018, as revised May 4th, 2018. Actually, no, they're dated April 17, 2018. I'll call them, there are two different plans that we'll be talking about. I'll call them the pitched roof and the flat roof, just for simplicity. Rested on general statements that they liked the pitched roof better. They thought it looked nicer. You can find no discussion in the record regarding the several factors that they're supposed to apply, including the Secretary of State's Secretary of Interior standards. I'll move on to the weight of the evidence does not support the decision. The decision on page 3, section E, findings of fact, states that, quote, the proposed construction will be compatible with the massing, proportion, scale, and size, and the spatial relationships of the surrounding environment because the proposed construction reflects the historic and architectural history of the area. This is not true, and the weight of the evidence that was presented before the Historic District Commission was entirely on the other side. The Protected Waterfront District is recognized, as you may know, as having a unique small scale. The question concerning whether the construction reflects the historic and architectural history of the area is one that requires specialized knowledge. So accordingly, it's one for which expert opinion is appropriate. And in fact, the HDC did hear from a number of experts. The applicant produced no one who had expertise in the field of historic preservation or historic architecture. On the other side of the scale, and again, we're talking about the weight of the evidence, on the other side of the scale, the applicant or the objectors, the appellant or the objectors, presented or were supported by 8 experts in the field of historic architectural preservation, historic and or architectural historic preservation. And I say they were supported by them because some of them came to the meeting independently on their own when they heard what was happening and presented their own evidence. So let me run through who was presented on this issue very quickly and just touch upon the highlights of who they are and what they said. The main expert for the developer was Douglas Kalfels. I believe it's spelled K-A-L-L-F-E-L-Z. And he's an architect and a principal and manager of the Union Studios, which is the firm that the developer had hired. He has no credential related to historic preservation, historic architecture. He talked about the HDC guidelines in several respects, but he just simply didn't have the expertise, nor did he go in depth on the historic preservation and the appropriate structure to maintain the historic character of that unique area. The next one was Edward Pimentel. He had no historic preservation or architectural certifications or education. He was accepted not as a historic preservation or architectural expert, but as an expert in zoning and land use. And he had some experience in municipal planning. He spoke about density, massing, scaling, variances needed, but he was not able, because he was not an expert, nor was he accepted as an expert in historic preservation, and therefore he did not talk about the appropriate character of that area and what type of building was appropriate given the historic significance of the area. The next expert that the developer presented was Peter Scotti. Many of you may be familiar with Mr. Scotti. He has 30 years of experience as a real estate appraiser. I think if you asked him, he would say, I have no historic preservation or architectural credentials, and he would be right. He talked about valuations and economic impact. Then Sam Hemingway, he was a civil engineer, and he spoke to environmental impact. So that was the sum total of the experts that the developer presented on the issue of whether this was historically appropriate. On the other side, there were, as I said, there were 8. And they are as follows. Philip Marshall spoke out against the project. He had 40 years of teaching and consulting in historic preservation, 27 years at Roger Williams University as a full professor, and the coordinator of the Historic Preservation Program. Historic Preservation Program. P-R-O-G-A.
Coordinator.
As a full professor and coordinator of the Historic Preservation Program. Sorry, when I read, I start to go more quickly. I apologize. Multiple graduate and undergraduate degrees in historic preservation, art and geology, international, national, state, and local experience and reputation. He voices strong opposition to the proposed Belvedere-at-Thames project. He testified that the Bristol Waterfront Historic District is of incredible significance integrity and livability being the key to that. He noted what he had seen nationwide and the devastating effects of misguided development on communities and in particular historic districts. And he said that the proposed project was contrary to HDC guidelines as defined for new construction in the historic district, which is Article 3, which I'll get back to as a clear error of law. He also noted that the proposed project was contrary to the Secretary of Interior standards for rehabilitation, which is the basis for the HDC guidelines, including but not limited to Standard 9. Next witness was Fred Statura. His credentials, Statura is S-T-A-C-H-U-R-A. And he has a master's in preservation studies and a bachelor of arts in history, 19 years of experience in historic preservation, community redevelopment as a planner, preservationist, specialist, liaison, consultant, and teacher on historic preservation law, planning, and public policy, including 12 years at Roger Williams University School of Architecture, Art, and Historic Preservation. He's an East Bay native, and his points were very similar. He spoke out against the project very strongly. He indicated that it does not address the HDC guidelines, and it was incompatible with the comprehensive plan, which goes more to the planning board's consideration. He said, and many of the experts that objected to this, that the central issue in the building was the form and massing. Essentially, that the building was just too large. Its mass, combined height and width, and its unchanging facade would present an adverse impact on the existing historic district. And again, he noted that this was a highly significant historic district, the original heart of the 1680 Bristol community, and the oldest extant and intact early town plan in the state. It's listed on the National Register of Historic Places in 1975. So that was his testimony. Again, very focused on what the HDC was supposed to be guided by. The next expert was Hassan Uddin Khan, certainly, H-A-S-A-N-U, capital U, D-D-I-N, Khan is K-H-A-N. And he is a professor of architect and historic preservation with 46 years of experience teaching at MIT, Roger Williams University, University of California, Berkeley, and internationally. His overall conclusion, which is similar to many people who spoke out that night, was that he was in favor of development of the site, but that this particular proposed structure, and this mirrors what the appellants said that evening, not against developing the site needs development, but that this particular structure would adversely impact the historic and architectural values of the surrounding structures and surrounding area. And that he also testified that the proposed project is contrary to the HDC guidelines, and that in particular he said the proposed structure, and this is a quote, presents a mass that will dominate and diminish the character of the surrounding buildings. This will result in a denigration of the historic character of the area. For this reason, he said it was contrary also to the comprehensive plan. The comprehensive plan. The next witness was Shantia Anderhagen, again an expert speaking out against the project. Shantia is spelled S-H-A-T-I-A. Anderhagen is A-N-D-E-R-H-E-G-G-E-N. She has 25 years of experience in historic preservation, historic property real estate, and American architectural history. She's the former director of preservation at the Newport Restoration Foundation, and she's the former director of the easement program at the National Trust for Historic Preservation. She has a master's in preservation studies and a bachelor's in art history. Her testimony, to not go over it point by point, but was very much in line with what I just told you. She focused particularly on the Secretary of Interior standards, saying that this project violated several of them. The next expert was John Turch. I'm going to spell this one for you. Tschirch. Mr. Church has a master's in architectural history and a Bachelor of Art in history. He had 33 years of experience in the fields of historic preservation, conservancy, architectural history, teaching, and curatorship. And he was also a 22-year property owner in Bristol. And he spoke very, very movingly about the project. And he said that Bristol's historic assets are the primary features of its commercial and residential enterprises. Effective economic development respects these valuable resources rather than compromising them for quick financial gain. And that was his point, basically. If you ruin the historic character of the area, which he felt that this plan would, you're going to basically kill the goose that lays the golden egg, because you're going to denigrate the historic nature of the downtown district. And he noted that there were a number of different types of alternatives that exist for reasonable development, including breaking up it in the development into smaller buildings. Next expert, this is number 6, so we're getting close. She was the executive director at Preserve Rhode Island. She spoke out against it, and she noted that Bristol's waterfront historic district, to her mind, was one of Rhode Island's premier historic places. And she also noted that the current proposal violates the HDC guidelines because of its substantial visible mass, including rooftop enclosures. She indicated ideally design would incorporate separate buildings. Again, she was not against development, but she was against the mass and thought that it was not historically and architecturally appropriate.
Could you give us that individual's name, sir?
Sure, Valerie Talmage, which is Talmage. Next one was expert was Catherine Ziff, which is Zipf. I think that's how she pronounces it. She was the executive director of Bristol Historic and Preservation Society. She did not oppose the project, but opposed the height, and noted that the height violated the Secretary of Interior standards and HDC guidelines. And she noted that the inappropriate size will undermine the town's investment in the area, such as the armory and the gladding buildings. And that she also noted that it will set a negative precedent for future development, which will affect, or further affect, the historic character of the downtown area.
That was 7.
That was 7. And that's it. That's it, I'm sorry, I have 7. Catherine's at 6, that's 7, you're right.
Thank you.
So that should give you just a sample of the experts who came out against the project versus mostly hired architects and engineers that testified on behalf of the project. And again, the key here is the historic preservation, and I will note that, again, the portion of the decision that I think is not supported by the weight of the evidence is this language that says the proposed construction will be compatible with the massing, proportion, scale, and size, and the spatial relationship of the surrounding environment, because the proposed construction reflects the historic and architectural history of the area. That's just not supported by the expert testimony on the record. Now, as to clear error, the Historic District Commission's decision to be vacated because it is clearly erroneous in the view of the reliable, probative, and substantial evidence contained in the whole record. And this is what happened during, board members may be aware of this, that there was a peaked roof plan that was presented early on. The planning board in particular said they had problems with it. They changed the proposal to a flat roof plan. That was the proposal that was pending when public comment and these experts gave testimony. So there's clear error in that in essence, there was no testimony on this earlier peaked roof plan. What the applicant presented was a redesign. And the applicant came forward and said, I have this, quote, new flat roof design. And every one of their witnesses testified about the flat roof design. All of the analysis and exhibits related to the flat roof design. Viewscapes and massing related to the new design. Height, visual impact, and scale were all with respect to the new design. And the bulk of the testimony did not touch on pitch roof because it was gone at the time. Accordingly, the HDC committed clear error in the ordinary error of procedure. Yes. Accordingly, the HDC committed clear error or an error of procedure because it had almost no evidence presented on it with respect to the several critical factors that it had to consider with respect to this peaked roof plan.
So just so I'm following what you're saying, Mr. McGillicuddy, there was initially presented a peak design, but then that was supplanted by a flat design.
That's
and
correct.
Eventually returned to the peak design.
Well, it was returned only when the Historic District Commission and the Planning Board started to, they closed the public hearing and started their deliberations. Now, people did mention the peaked roof design during the public comment. In fact, Edward Pimentel said, as an aside, oh, I think the peaked roof design that we were presenting would have been a better idea, but then went back to talk about the flat roof design. All of the members of the public that were there came to talk about the flat roof design.
Was the peak roof design that eventually was approved the same design as was originally presented?
That I'm not sure. I think it was different than even the one that was originally presented. So I think it represented a hybrid of the two. But I would have to go back and check the record on that. But in any event, what you had was basically a member of the Historic District Commission at the last moment say, you know what, I really like that one. They before this whole thing started, they presented with the peak roofs. I'm going to go with that. And so there was no opportunity for public hearing on that, and all of the testimony was, or I should say 99% of the testimony was relative to the flat roof design, because that was what was being considered at the time. Again, the decision makes reference to this one sentence by Edward Pimentel where he basically says, oh, well, I would have liked the one that we did a while ago, but now we're here on the flat roof design. Now the next clear error that the HDC made, and this is an interesting one, it's in the decision, the HDC relied on a building. They have to look at the surrounding areas and they have to look at the surrounding buildings and to make sure that the new construction is compatible under their guidelines. And in the decision, they state, there may have been testimony of this, but in their decision they state that their reference point is the DeWolf Hotel. Now, the DeWolf Hotel doesn't exist anymore. It was constructed decades before the adoption of the land use regulations in the town of Bristol. And referring to it to support the size of new construction, something that's literally not there, is a clear mistake.
So was there evidence presented during the hearing about this DeWolf Hotel?
You know, Mr. Cogan, I remember them, I remember some conversation, I can't point to line and verse where they talked about it, but it's in the decision from the HDC.
I understand it's in the decision. My question was there evidence presented during the testimony of the developers, experts, about compatibility in comparison to this now no longer existing the Wolf Hotel?
I believe there was. And my point being not that it wasn't presented, but that it was inappropriately relied on. Now, the decision on page 3 also states that the HCC is relying on a previously approved project of similar density, size, and height over a decade ago. The approval for that reference project expired in 2010 and can't serve as a historic or architectural reference point for the current proposal. Well, relying upon that is clear error. The decision on page 5 states that the HDC considered this project without, quote, without regard to whether the Commission's decision will, quote, set a precedence. That's an error also, and that was an instruction that they got from the town solicitor. Although it's generally true that each case has to be considered on its own, when they asked, are we setting a precedent, they may not have been setting a legal precedent, but because all construction is based upon what's already there, particularly with respect to size and scope, or size and massing, I should say, once you allow an outlier into the neighborhood, you've basically put a jimmy in the door for future similarly sized buildings. So they were specifically instructed, no, this will not have any effect on the future. And they relied upon that, both in their discussion and it's represented in their written decision as well. Again, generally true as a legal matter. Each case, as this board knows, has to be considered on its own merits. But when your actually guideposts under the law state that you measure new construction by what's there, when you allow a vastly larger building into the neighborhood, you reset the standards. So, and here's, I think, one of the most important areas where there was error, and this goes to what your temporary town solicitor said. If there's a law that says X, and they just go ahead and do Y, then that's clear error. And here we have an example of that. The proposed building violates Bristol's Historic District Commission guidelines for rehabilitation, additions, and new constructions, in particular Article 3. That area guides new construction in the downtown waterfront area, which is located west of Hope Street between Church and Franklin Street. This area is recognized by Bristol as the most significant historic district in the town, specifically because of its small scale, its structures, its walkability. You folks know the area. The area is defined separately from the rest of the town because of its unique, and this is quoting from the guidelines, unique physical, historical, and environmental aspects. Article 3 gives the Historical Commission a little further guidance. It says, with the exception of the mill complex to the north and south end of Thames Street, the area is characterized by small buildings on the conventional sized lots. And then comes the directive, the last sentence. This small scale should be respected. Now, I don't know if I have a copy of it for you, but Exhibit T that was presented by the objectors is a depiction of all of the houses that are guided by Article 3. I have an extra copy if you'd like to look at it while I discuss it, because it's a very important exhibit.
think it's in there.
If anybody needs a copy of
Yeah, right here.
Steve,
So this was the exhibit that the objectors presented, and you can see in box A, they figured out the building shape index, horizontal and vertical thrust, and of all of these buildings, and then the subject. And you can see from this, well, first of all, you can see by just looking at the pictures what the historic nature, size, and scale of the existing buildings are. And then exhibit, or I should say box A and box B show you in graphic form that this proposed project does not respect the small scale. In fact, it flouts the small scale. The average building height without the Belvedere Hotel, or I'm sorry, with the Belvedere Hotel is 30 feet. This one is 47. Without Belvedere Hotel, it's 21.9. The average width is 36. So all of these buildings, and these are all the ones that are to be considered under Article 3, are smaller, I would dare say more historic looking, and the expert said promote walkability and represent the historic nature of that area. Exhibit T was not mentioned in the by the board in its decision. They ignored it.
so this document was Exhibit T? Is
That was Exhibit T, yes. The applicant, the developer, actually presented a similar exhibit, but it had buildings outside of what Article 3 prescribes. So to the extent the Historic Commission took those exhibits into mind when it made its decision, it applied the wrong standard. The standards, again, is very specific. It's not to include the mill complexes. It's characterized by small buildings on conventional sized lots. This is neither. And the small scale should be respected. And that Article 3 is a perfect example of what your town solicitor said. The law says A, and they went ahead and did B. And therefore it's clear error.
I got one question on this. Belvedere Hotel, how tall is that? The height?
Oh, you're going to have
Yeah,
the,
check it out.
I couldn't hear the question.
how tall is it?
Oh, well, six stories from the rear, over
Over 40. It's, they have all of them here.
I believe that's 423 Hope Street.
The
And on this,
Belvedere Hotel is not in the district.
Oh, it's on the district.
we're not looking for comments from the audience at
Oh,
this
sorry.
time. However, just in reference to Exhibit T,
Yes.
that was submitted to the Historic District Commission, your document called Historic Neighborhood Comparison to Subject Proposal.
Yep.
It appears 423 Hope has marked a height of 45 plus feet and a width of 66 feet. Would that be accurate?
It is accurate. It's from the property card. But again, and I'll just make a point with that. Height alone, when all these experts talk, and when the historic district guidelines what they discuss is scale, and they talk about mass. And height is only one element of mass. Mass is the feeling, you know, that the building is imposing, that it blocks out the sun. And so what these charts reflect is the horizontal and vertical thrust, which is a combination of horizontal and vertical, and therefore the building's mass. And that's where it's so dramatically out of place with the rest of the district. It's not only that it's too high, it's that its height combined with its long stretch of building presents a mass that is not appropriate for the historic district. And more importantly, you're not making that decision tonight. You're deciding whether they made an error. And it's clear from the record that they did not follow Article 3 or even attempt to apply it correctly. So, and to that, again, on this exhibit, on the upper graph, the surrounding buildings have a horizontal vertical thrust valued at roughly 1,000, 2/3 of them. All 24 measured buildings surrounding the proposed Belvedere-at-Thames building have a horizontal vertical thrust of less. Sure. Surrounding the proposed building have a horizontal vertical thrust of less than 2,000. The subject building, its dimensions yield a horizontal vertical thrust somewhere around the 6,000 level. And again, from those charts you can see it's a clear outlier, and it does not respect the existing buildings and their scale. Finally, the proposed structure violates Article 3, General Criteria 1 and 2, which require that the public views of the waterfront from both the public property and the existing private structures must be considered in new construction, and that the design of the buildings for this area will be judged from all elevations, including those visible from the water. Again, you have the same problem here where you have the flat roof being proposed and talked about, and you have the peak roof coming in at the last moment when someone on the HDC suggests that they might prefer it. And it violates Secretary of Interior Standards 1, Standard 8, and Standard 9, among others. And for that reason, the appellants seek a reversal and remand for reconsideration, and seek an order ordering the Historic District Commission to hold a separate meeting where it can take its own testimony instead of testimony which what happened in essence was they took testimony from the planning board, listened to the planning board, which is inappropriate. The planning board has no more right to speak to the Historic District Commission than any member of the public. They should have been sworn in like the other members of the public, and they should have spoken during public comment. But instead, they unduly influenced the planning board during its closed deliberations after public hearing had been closed. So those are the highlights. The rest are in the application. I'm sure members of the public will have some other areas where they feel that the Historic District Commission made procedural, factual, and clear errors, but I'll leave that to them. Thank you.
Again, for the record, my name is Andrew Teitz, T-E-I-T-Z. I'm attorney with offices at 2 William Street in Providence, representing the Bristol Historic District Commission on this appeal. Let me note my introduction that this was an unusually divisive application in the town of Bristol. perhaps the most divisive I've seen in the last 30 years, or close to it. There were hearings that extended over several nights, several hours. A lot of people spoke in favor of it, a lot of people spoke a 3 vote. So that doesn't tell you this is something that reasonable people can disagree on. I don't know what it says. So with that, the other interesting thing is that where most of the previous fights over the historic preservation in Bristol have been over preserving structures, whether to demolish or preserve structures such as the Pastime Theater or the furniture store that became part of the library and the like. What you have here is a vacant lot with, that's one parcel is a vacant lot, and the other parcel has a steel and concrete parking deck. And then also on that other parcel is the Belvedere Hotel and 2 other historic structures, a carriage house and another house there. So the part that we're talking about, the particular approval which is before you, is for the vacant lot and the steel and concrete parking structure. So I think right from the beginning, you have to get into that and realize that you're not so much dealing with the Secretary of the Interior standards for historic rehabilitation, other than to the extent of its new construction and you're looking for the compatibility with the existing structures. We're not talking about destroying a historic fabric that's, because there is no fabric there at the moment. So with that, I want to take this in a couple of ways, and I think the first thing that I'd like to do is just address a couple of the items that Mr. McGilvery did not address in his written remarks because he said he's not waiving them, and I don't want you to think that I'm waiving them. I kind of disagree with some of it, but wasn't mentioned. One of his arguments under errors of procedure, section 1, numbered 1B, but he talks about the joint meeting. He says, moreover, the HDC consideration of statements by the planning board members who are not under oath constitutes a violation of HDC's own procedure and practices. This is not the case. The HDC does not swear in witnesses. I won't say they never have because we actually did try it for about 2 meetings worth and then gave up the practice, but never have before and never since, and that was several years ago. So the HDC does not put any of its witnesses under oath, so there is absolutely no truth to that allegation. Also under errors of procedure not mentioned in this is 1E. Town solicitor improperly advised certain members of the HDC that they must recuse themselves. I do not know what this is referring to. One member of the HDC recused himself. That was Ben Birkenholtz, whose parents are the owners of one of the Birkenholtz. I believe it's B-E-R-G-E.
And H-O-L-T-Z.
I adopt that spelling. Whose parents are, in fact, the shareholders of 2 of the appellants here tonight. And he did recuse himself. And I may have advised him of it, but I don't actually recall it because I think he's been recusing himself all along. So I don't know what other person they would be entitled. I think this is just a cross typo from the other appeal where they're raising the issue. But in that case, there are 7 members of the Historic District Commission and 1 alternate. Mr. Birkenholtz recused himself right from the beginning, and the alternate sat, and there were 7 voting members. And as I mentioned, the vote was 4-3. I think those are the only significant things that weren't mentioned that I wanted to challenge. Unfortunately, I think we're going to get to a longer part with the other things that were mentioned. So I think it might be better just to take it in order. And I want to first discuss, as you did, the standard. I think we're fairly well in agreement of it. Prejudicial procedural error. And that's the other issue that I wanted to raise that was not raised by Mr. McGilvery at all. In his written argument, they claim that they did not receive notice. Or actually, no, I'm sorry, that's their planning board one. So, never mind. But prejudicial procedural error would be an example. If you didn't, even if you didn't receive notice and you appeared, that's not prejudicial. Clear error, I think you've gotten the answer. Even Mr. McGilvery's attempt to make it a little more defined. Unquestionably erroneous. I don't know how unquestionably erroneous is any better than clear error. I think you know it when you see it is probably the best you're going to get. And then not supported by the weight of the evidence. I think this is important because this is a big issue here. And I want to remind you that what the standard of not supported by the weight of the evidence actually goes to, there's language in both of the state laws. For the HDC, section 45-24.1-9 of the Rhode Island General Laws starts off with, when hearing appeals from commission decisions, the Zoning Board of Review shall not substitute its own judgment for that of the commission, but must consider the issue upon findings and record of the commission. And then the next sentence is, the Zoning Board of Review shall not reverse a commission decision except on a finding of prejudicial procedural error, clear error, or lack of support by the weight of the evidence in the record. And I didn't bring a particular case with me on this, but the weight of the evidence in the record has been dealt with by many, many cases in Rhode Island. And essentially what our Supreme Court has said is that you must find sufficient evidence to support the decision, and sufficient evidence is more than a scintilla, but less than a preponderance. So you don't look to see, here's the evidence that was before the HDC, and you weigh it and say, okay, well, you know, it was really 70% in favor, that's the weight of the evidence for the HDC, and there was only 30% the other way, and so we think it should have been the 70%. You look to see if there's more than a scintilla. There's 10, 15% of the weight of the evidence in the record to support what the Historic District Commission decision was, then you must uphold it. It's not your position to weigh that evidence. That's for the HDC. So with that, let's go talk about the specific issues. On the procedural question, the voting on the future guidelines. I think the guidelines of the Historic District, and in particular the ones that he's talking about, which are the new construction west of Hope Street, the ones that are 31 years old. This is somewhat similar to the question of consistent with the comprehensive plan. There are things in the comprehensive plan that you can take out and read any way you want. You can say, oh, economic development, well, that's for. And then we go to the open space chapter, well, that's against. And so that's something that the boards have to weigh and consider when they're looking at consistency with the comp plan. And the same thing with the Historic District Commission. They can't take one little set of guidelines in a vacuum, and one in particular. They've got to look at it all and weigh them all together. So the new construction west of Hope Street, there's actually a total of 5 separate criteria, one of which is the one that they're talking about specifically, the small scale, which I'm going to talk about later, the 1, 2, and 3. But I think that as far as the question, not on the weight of the evidence question, but on the question of error, I think it is appropriate that it is something that the HDC weighed and has to look at it. And part of that includes...
So, Mr. Chase, why does the decision of the Historic District Commission refer to the fact that the guidelines that the Commission is obligated to follow are 31 years old and in need of updating. Why is that in there? You know, if your argument is they applied the existing guidelines and criteria and they had discretion, and as long as there's more than a mere scintilla of evidence, we have to uphold that. Why is that even in there?
Because I think it goes to their question of the weight that they were giving it as to the overall circumstance. I mean, certain of the requirements, for example, that talked about where exits should come in from the streets and so forth, were no longer applicable because buildings weren't there. And I think that's the argument too, that when looking at this question about this area is characterized by small buildings on conventional sized lots. A lot of the buildings that were the small buildings on conventional sized lots don't exist at this point, but existed when these were written. Particularly if you think of Thames Street Landing and the new hotel. At Thames Street Landing, diagonally across the street. Yes, there's small buildings there, and then there's also a large, newer building there. Though that building didn't exist back when these guidelines were written. When the guidelines were written, there were old warehouses that were on the subject site. So that's the point of why I think the 31 years is important as to what weight they're given, as to how relevant they are to the current situation. I think the overall question is the same. If there is one question that the HDC really has to answer in this is, if this is built, is it going to be compatible with what's around it in the district and what we expect the district to be? That's the question. And as I said, clearly even 3/7 of the HDC didn't agree with that. Different people had different things, and different people looked at different examples too, which is, I think, what did it. We don't have a monochromatic Disneyland historic district. We have a very diverse historic district, and I think if you can see that in reading the discussion with the Historic District Commission's discussion. And this isn't even the first, I mean, this is, I think, the third architect and the fourth set of plans that were before the HDC over time. They went through many different iterations. And that's the question. What do you look at for the model? Do you look at John Rago's office on Hope Street? Do you look at Judge Roy Bean? Do you look at the Belvedere? What model do you look at? You have to look at all of this. And also I would submit on behalf of the HDC that the Wolf Hotel is something to look at. You have to look at all of that.
When was that demolished?
I believe, I think...
Is there any testimony in the record
there was,
when that was demolished?
I believe there was, because someone came up and talked about it. There was a very large photo of it on a like 24 by 36 poster board photo of it, and I believe there was testimony. I don't know exactly whether it dates, whether it's 38 with the 38 hurricane or later. I don't remember when it was demolished. It has been gone for decades. I do know that.
So it was gone before any of the 31-year-old guidelines were developed?
Yes. So coming back to what we were talking about, the procedural error, I do not believe it was prejudicial procedural error to balance out part of the 31-year-old guidelines with all the rest of the guidelines. The HDC has several sets of guidelines. This was one set of it. They have the Secretary of the Standards. They have their own local guidelines. They had this one little section here. I don't believe it was prejudicial procedural error to balance out that one section and not say, oh, this takes precedence over everything else. I think that would have been error to say, oh, this takes precedence over everything else, this one statement. The joint meaning claim that taints the procedure. Obviously, this is something that you will have to decide. I do not think that there's any taint to it. It was not prohibited To my knowledge, it was not objected to at the time. It was only later that this objection has come forward. I don't know whether you would consider that on a raise or waive basis. But all the procedures of both of the bodies were met. They were advertised. All of their individual advertising and notice requirements were done. All of their individual requirements were done. They voted separately. The fact that they were on the stage together to hear this, and so to hear it over 3 nights and 12 hours instead of 6 nights and 24 hours worth of time, I don't think that's prejudicial procedural error. And as I noted, the HDC does not swear in its people before testifying, neither does the planning board. I don't think there was any error from the discussion between the bodies. They were there on the stage with microphones, which they were vigorously encouraged to use so that everybody could hear what was being said. It was all part of that same public meeting. The third point, the question about the decision being a fiction because it was written by the town solicitor, myself, I'm going to reference you to an old case that has been cited before. It goes back to 1967. Since 1967, our Rhode Island Supreme Court has been saying, actually encouraging that boards utilize solicitors for their decision. The case is Belvedere versus Zoning Board of Pawtucket, 230 Atlantic 2nd, 247.
The board wish to have this as a demonstrative exhibit?
Okay. So I'll just read the pertinent part, which I have highlighted at the bottom of page 3. We recognize that board members are without legal training or experience in decision writing. That recognition has prompted us during oral arguments in zoning cases to suggest to city and town solicitors that they offer their assistance to their respective boards in the decision writing process. We repeat that suggestion, and at the same time we advise zoning boards that it is within their prerogative to request counsel who appear before them to submit suggested findings of fact and conclusions of law. So it is not at all any error, let alone prejudicial error, for the solicitor to provide a written decision. This decision was presented to the zoning board ahead of time. It was actually provided to opposing to all counsel ahead of time, and it was discussed in an open meeting. In fact, there were some changes made. Board members wanted some changes made, and it was made right at that meeting. There were some particular changes. So there is no error in that.
Did you not mean the historic district? You said zoning board.
I'm sorry, the Historic District, yes, I meant the Historic District Commission. I'm looking at you, but yes. The Historic District Commission and the Planning Board, they both had it ahead of time, and they both had discussion on it as to what was in the decision and what changes they wanted to it. So that certainly is not error nor prejudicial. Now, as you get to the weight of the evidence, you've heard from Mr. McGilvery about the different experts. And I just want to note a few things. I do want to note that I think the Historic District Commission itself has somewhat of specialized expertise. They have been hearing this, several of the members, for some time. They are deemed to have that knowledge, just as a zoning board is deemed to have local knowledge of its community. And it wasn't quite as one-sided as it said. Some of the people that are cited in Mr. McGilvery's written appeal, as well as his statement here, were not there to testify in person. They submitted statements or affidavits. but they were not there to testify in person. There definitely were people there in person, and I certainly agree that there was expert testimony on both sides of the issue. I think your question that you have is the testimony, the expert testimony, and it was particularly by the applicant's architect, whose resume is in an exhibit and who does have experience with historic structures. He might not have a degree in historic architecture, but he has experience in historic structures, and he is an architect and deemed an exhibit. Was that sufficient? As opposed to weighing others who said to the contrary. That's something that you would weigh. I would say that it is more than a scintilla in support of the application. There was an architect who has experience with construction in historic districts, and he testified in favor, and the Historic District Commission saw fit to accept his testimony over the others.
Now, Mr. Tights, is there a reason why the decision of the Historic District Commission doesn't address the expert testimony that opposed the project and explain why that testimony was not relied upon? I mean, it doesn't from the decision appear that any weight was given to the expert evidence against the project.
I think that my only response to that is it was a very long hearing over a long period of time. I think that when the overall discussion of the compatibility, because that's really, again, even what the experts were talking about, is, is this compatible with what's around it? And it really just came down to that same question. Is it compatible with what's around it? Comes down to what do you define as the neighborhood around it? How do you define that neighborhood? And I understand, no, I don't think there's anything specific about that in the decision.
No, I mean, it certainly would make it easier for this board to review the Historic District Commission's decision if the Historic District Commission had indicated why it relied on the expert testimony of
Mr. Kalfas,
as opposed to the 4 or 5 experts who did testify, disregarding for the moment the written submissions. But there were experts who testified in opposition, and the decision doesn't present any explanation of why it chose to rely only on Mr. Kalfas and not at all on the other experts who presented evidence. So just the commission didn't do that.
The decision does not happen. Moving along to address the question of clear error and the question of the plans that were before it. It's been suggested that the Historic District Commission committed clear error because the peak roof plan was not before it. And I would point out that the Historic District Commission approval process, as is the Planning Board process, are both iterative processes, as opposed to a quasi-judicial process like the Zoning Board, where they often go through multiple plans. And in this case, with the Historic District Commission, there were multiple sets of plans even before they got to this stage, including at this stage here. There were 2 plans. It was still there in evidence, and it was still testified to. There was still a lot of that back and forth. A lot of the experts that testified against it because of the flat roof. That was part of the scale and the massing. They said the flat roof, that it was bulky. That was part of the testimony against it. So to penalize the Historic District Commission for listening to the testimony before it and weighing it and looking at all the examples. And in fact, following, for example, the disputed issue on on Article 3, when it talks about the exceptions of the mill complexes on the north and south ends of Thames Street, which are in fact much taller, but they're flat roof. So the action of the Historic District Commission to reject the flat roof mill building model in favor of a design which has a peak roof, even though at a higher height, which will need more of a zoning variance, was part of their deliberative process as to what they thought would fit better into the neighborhood, looking at the buildings around it. And they had to weigh it because there were flat buildings and peak roof buildings and mansard and gables all around them. So that was part of their process. But it was certainly always there in the record, and it was discussed. It wasn't something that was pulled out of a hat at the last minute. In fact, it was the previous plan. There's discussion, and you were given Exhibit T as an iterative exhibit here today. I was looking, I don't appear to have a better copy or the original color copy. I don't know whether that's a 45 or 55 or 65 for the height of 423 Hope Street. I'm not sure, but I hopefully that's something that can be resolved. I believe the original exhibit is bigger and in color, and it should be clear. Unfortunately, Mr. McGilvery couldn't answer it for you, and it was, I believe this exhibit was presented on behalf of his clients. So I would point out, though, and this goes to the question of that overall question of what's the neighborhood that it's compatible with. And if you look at the closest buildings to the site, directly to the north is 1 State Street, otherwise known as the Judge Roy Bean building for the restaurant that happens to, or maybe it's got a new name already. No, it's still, that's what we know it about and the height there, and many of the plans in the that were before. In fact, all the plans that were submitted to the board had that building, because that was a question. Well, what's that building across the street? We want to look and see how high is that building? How high is your building going to be in comparison to that building across the street? And then there were a lot of discussion as to how do you measure that height? Do you measure that height as the average grade and whatnot? And the answer was, well, from sidewalk to roof, how high is it looking at those heights? And the same thing too with the Belvedere, even at 45 feet, that's the closest building on the other side to the southeast. And 17 John Street, which is the closest building to the south, is at 38 feet. So I think those are the things that the HDC had to weigh. And I think that, with all due respect, the zoning board sitting as the Board of Appeal should not be substituting its judgment for that of the Historic District Commission in making that kind of weight. And then specifically dealing with the Article 3 questions, it said that there was the public views from the waterfront were not considered from both public property, existing private structures, and all elevations. And I would respectfully disagree. I do think those were considered and noted in the decision itself that they were considered. And again, as we come down to this question of Article 3, general criteria number 3, the small scale should be respected. The question is, when you look at that whole sentence, with the exceptions of mill complexes on north and south ends of Thames Street, the area is characterized. That's the question. What's the area characterized by? That's what they debated. That's what even the HDC split. But the majority of the HDC made a reasonable finding of fact that it was characterized by enough of the larger buildings that this was not out of scale for that. A couple of other issues was the question about that this relied on the earlier expired approval, and I just want to make it clear it did not rely on that. It's listed there It's kind of like you were presented with a Superior Court case by Mr. McGilvery. It's persuasive opinion. It's not binding, but it's persuasive. It was one of the things that helped to persuade. And then the question of the lack of precedence, finally. Even Mr. McGilvery's arguments were that it is generally true and has a legal aspect, legal precedent. And that's what the question was, and the answer was there. And I think you'll all agree too. You've got the same question. Each case stands on its own merits. And it isn't a legal precedent that's binding on the future, and therefore it was an error to find that it was not a legal precedent going forward. And with that, we'll rest unless you have any further questions.
Any questions?
Thank you for your time.
Good evening, ladies and gentlemen of the Bristol Zoning Board. My name is Attorney K. Joseph Shikachi, and I represent 423 Hope Street Development LLC and SAT Development LLC partners, the developer of this project. I won't be long because I think Mr. Tights said a lot of what I was going to say, and he said it very well. But I'd like to just address a couple of points that were made. Much has been said about your role here today, and I know you're reviewing the record, and I think it was Mr. Kogan asked, well, why didn't this information make it into the decision? Well, respectfully, as you know from your deliberations as a zoning board, you don't put everything that you hear as part of the decision, especially some of the non-credible evidence. And that's what I think. I'm only speculating. I don't represent the Historic District Commission, but the evidence that they left out was evidence that they probably felt wasn't credible. I mean, a lot of these, Mr. McGilvery repeated all of these experts that came in and said this. Well, some of them didn't show up. Some of them were self-proclaimed experts. We didn't get a chance to voir dire any of them. I don't know if they even appeared before a court as an expert, but ultimately the Historic District Commission listened to them, as you do as a zoning board administrator. The issue is not admissibility. The issue is credibility. When people come before an administrative board, you let everybody be heard. That's the nature of our democracy. So you let everybody come in, and then you as a board, just as they do, as the planning board does, the zoning board does, you make your decision based on the weight of the evidence, the credibility of the evidence. As Mr. Tights said, there was ample evidence on the record. I'd like to just address that. Not only was there the testimony by Union Studios, there was an application, a very long, detailed application that presented two options of the roof. And a lot of that expert testimony that was talked about, Mr. McGilvery, one was somewhere against the flat roof, somewhere against the peaked roof. So half of that automatically gets disqualified because it wasn't ultimately the application that was approved. Mr. Pimento submitted a detailed report. It's part of your record. I suggest you look at that if you want to make a decision. That was, again, part of the evidence that the Historic District Commission based its decision on. And ultimately, finally, the application, Union Studios' testimonies and plans, Mr. Pimento, but the decisions themselves. Another issue was raised about why there was 31 years, or there was mentioned that the guidelines, emphasize the word guidelines and not laws or requirements, were put in there, or in the decision. Why was it mentioned? Well, a lot of things have happened in 31 years. Our federal FEMA regulations have changed and continue to change. The fire code in the state of Rhode Island has changed. We had a tragedy several years ago, the station fire, that's changed. Matter of fact, the zoning laws that specifically apply to this property are going to be changed in March of 2019. ADA requirements have changed in 31 years. So I think that the board was very careful and deliberate about putting that in their decision. And I compliment either Mr. Tights or whoever put that in there because it made it clear that what we're looking at as guidelines are 31 years old, and there are other regulations we need to look at that are much more current as well. I want to talk about one point that was made about the it was a prejudicial error to combine the hearings. Well, that respectfully is false. And I don't know, and I'll stand corrected if someone can show me a law in Rhode Island or a case that specifically prohibits that. Because I have never found one in my 20 years of practicing law. Now, they may be out there and I may be wrong, and I'll come before you and say I was wrong, here's this case that says that. But I can tell you 2 years ago, the General Assembly passed a law to encourage and enable cities and towns to do unified hearings and develop it. And that's how the town of Johnston expedited the process to approve Citizens Bank. So that there's guidance that this is not only allowed, encouraged, or enabled by the state to, as Mr. Tice said, instead of 3 hearings, 12 hours, 6 hearings versus 24 hours. It just doesn't make sense for any, not this case, but any developer, anybody you want to come in town to do business. Again, I just want to go back to ultimately the standard that we talk about. You are not sitting as a zoning board tonight, you're sitting as a board of review. You don't get to judge the credibility of the issue. Was there evidence there? If there was evidence, there's no clear procedural defect. Were the notices correct? They were. Was the advertising correct? It was. And respectfully, you must uphold these decisions. Now, having said that, respectfully, all of you, you're going to get your bite at the apple, because this project has to come before the zoning board. And that's when you can weigh the evidence. That's when you can ask, do we have the proper experts on? Did we meet our credibility burden? Did the neighbors make an argument? That's not for consideration tonight. That was made by the Historic District Commission. They ruled in favor. They ruled that we met those obligations, and that was the decision. Rhode Island general law, as your counsel said, and as Mr. Tice says, is very limited on an appeal. I thank you. I appreciate your time and effort, and I'll be happy to answer any questions you may have. Thank you.
Thank you.
This hearing, so Mr. Hayden, we have to open it up on this hearing for public comment. Is that correct at this point?
I think that's appropriate, unless you want to ask specific questions first.
Right. What about the rules of procedure that provide for rebuttal? There was something in the rules of procedure about rebuttal.
Each side gets rebuttal.
Is that before or after the public comment?
I think it's most appropriate at the very end, after public comment, because there may be things from the public comment that they'll want to address.
Okay, we'll have some public comment. Would anyone like to speak in favor of this project?
Mr. Chairman, I respectfully object. I know that's your usual call, but you're not hearing in favor or support. It's in the appeal. It's only if they want to speak in particular direction to the appeal. So it could be, it's either in support of the appeal or against the appeal, but it's not the project.
That's what I was to be fair.
May I just say, this is a good example of why this town solicitor should not be advocating. He is crossing the bounds into the role as a solicitor. Really, these questions about when certain people are heard, procedure, or properly answered by the town solicitor rather than that.
I disagree. If either party has a problem with the procedure, they should say so, or perhaps waive that objection, which may be some of the issues concerning the appeal too. So I think it's important that if somebody either side has a problem with procedure, they should speak up. So that was entirely appropriate.
Well, I'll make a suggestion that the objectors go first, much like the appellants went, and then we'll go for the project and then the rebuttal after that. Although I'm indifferent to how it goes.
So, Mr. Hayden, is it necessary for us to separate out the public comment into pro and con, or could we just hear what people have to say?
You can do it either way, whichever you prefer.
Does anyone have a preference about that?
I'd like to keep them separate, just because this is a very complicated hearing. So if we could, either the ones that supported the appeal or objected to the appeal.
I think that makes the most sense to keep it clear and clean.
So, Mr. Chairman, we're starting with people who want to support the appeal, which would be supporting the objectors to the project.
Yes. Come up, please state your name and address.
My name is Caroline Jacobus. Can I be heard? Caroline Jacobus, Jacobus. I live at 35 Church Street. Thank you for this opportunity to speak before you. The decisions made by the Planning Board and the Historic District Commission on July 12th are critical to the future of Bristol. There can be no doubt that any approvals granted to the proposed Belvedere-at-Thames project will serve as precedents for all subsequent new construction within the specially defined waterfront historic district. The massive Belvedere building will become a dominating component of the built landscape that alters the waterfront and consequently serves as the precedent upon which future developers will apply to construct equally massive structures all along Thames Street, blocking views of Bristol Harbor, as do the Robin Rugg and Stone Harbor complexes, creating a shadowed canyon of looming condo buildings down which few tourists will be drawn. These July 12th decisions, if not overturned, represent blatant errors of procedure and fact, and decisions made against the weight of the evidence in that they clearly ignore the expert opinions submitted by 7 historic preservation experts, as well as the HDC's own guidelines, the Secretary of the Interior standards, and the 2016 Comprehensive Plan, all of which hold the force of law and require compliance for all HDC decisions. The July 12th HDC decision approving the proposed Belvedere-at-Thames project represents a clear error of fact because it does not enforce existing law. It fails to respect the definition of its own guidelines of the area in which the proposed project would be built. The downtown waterfront area is recognized by Bristol as the most significant historic district in our town, specifically because of the small scale of its structures, because it is the historic nucleus of Bristol's original 1680 community. This is the only downtown waterfront area that has not been eroded, blocked, and diminished by the construction of overly large 19th century structures which were built before there were any zoning ordinances. The Historic District Commission's own guidelines for new construction define the irreplaceable value of this area as follows, quote, "The following guidelines are for all new construction along the waterfront of Bristol. For the purposes of these guidelines, this is defined as any lot from the west side of Hope Street, but not including Hope Street, to the water, including Church, John, State, Bradford, Franklin, and Thames Streets. This area is defined separately because of its unique physical, historical, and environmental characteristics. With the exception of the mill complexes to the north and south ends of Thames Street, the area is characterized by small buildings."
Can you stop?
You're going a little too fast for the stenographer to take it down.
Okay, I will also submit a copy of my testimony so that if there are any questions, you'll have it.
I have a problem with that. We're not accepting.
This is taken straight from the guidelines.
If you're presenting something live, you don't therefore get to submit something written.
Oh, okay.
Even if it changes in less than what you would believe to be insignificant ways, I think you've got to choose one or the other.
That's fine.
And I think you've chosen you do it fine.
I'm happy to do it
So
live.
go right ahead.
Shall I start with this area? This area is defined separately because of its unique physical, historical, and environmental characteristics, with the exception of the mill complexes to the north and south ends of Thames Street. The area is characterized by small buildings on the conventional size lots, unquote. Excuse me. The small scale should be respected, unquote. It is an error of fact to compare the proposed project to the larger mill buildings that do not lie within the defined waterfront district. The July 12th HDC decision represents a clear error of fact because it does not enforce existing law, in that the proposed building violates Historic District Commission guidelines, which require the Commission to ensure that, quote, The relationship between the horizontal and vertical thrust of the structure should be designed in the context of the historic buildings in the immediate vicinity of the site, unquote. The proposed building would loom over the two-story Guillory's Tap House and Aiden's Pub, as well as the two Gladding Tin Shop buildings and the Pedigo Electric Bike Shop. At 47 foot 9 inches, the proposed project is 12 feet 9 inches above the maximum allowable height of 35 feet. In fact, when the enclosed elevator and stairway on the rooftop are included, as they should be, according to expert witness Steve Oaten, the structure soars to 52 feet, fully 17 feet, or almost 2 full stories above maximum allowable height. The proposed building is massive in comparison to the surrounding buildings. Built right up to the sidewalk, it will overwhelm pedestrians walking along Thames Street. The massiveness of this building has been an issue which has been brought up by the public and by expert witnesses again and again and again. To ignore that issue is to commit a clear error of fact. I am not submitting this as part of the record, but I am trying to say people do not grasp the massiveness of this project, and I would ask you to imagine Fenway Park's Green Monster Wall. As massive as the Green Monster is, it reaches only 37 feet 2 inches. The Belvedere building will soar another 15 feet 7 inches higher than the Green Monster and would stretch down Thames Street right up to the sidewalk for a full 176 feet of dead wall space, which is more than half the circumference of the Green Monster Wall. I am not submitting this for the record, but I'd like you to just see.
Well, Mr. Jacobus, I don't think you can do that.
Into the record.
Mr. Jacobus, you really can't do that.
You can't do that.
Ms. Jacobus, you can't do that. Please turn it around.
I think it was clear when we started that this is not a proceeding to add evidence, create a new record. We live with the record that we have and argue from the record that we have. If you want to make analogies, that's fine. But we're not here to compare a wall to a building and provide pictures. Okay?
Thank you for that guidance.
All right. I'm just trying to be fair.
Or you could envision the massiveness of this proposed building another way. There are 40-foot utility poles on the sidewalk at the corner of Thames and State Street. These are massive utility poles. The proposed project would top out at 12 feet higher than those 40-foot poles. The July 12th HDC decision represents a clear error of fact because it does not enforce existing law in that the proposed building violates Bristol's Historic District Commission guidelines, which require that, quote, the design of the buildings for this area will be judged from all elevations, including those visible from the water. This refers to Article 3. General criteria 1 and 2. So that the buildings on State Street would ideally march down step by step to the water, rather than having the new Belvedere building suddenly tower over all of the structures around it, or stick up over shoreline structures when viewed from the water. Dr. Frederick Statura stated, quote, all elevations of the project greatly impact the historic district, as these elevations will be visible from State, Thames, and John Streets, unquote. He found that, quote, the building will be substantially visible from all compass points and will have an overpowering, significant, and negative visual impact on the adjacent historic district, which is of a low rise and a mix of residential and commercial character. The structure as proposed is considerably out of scale with the surrounding buildings, unquote. That is your Exhibit F. This 52-foot high structure will obstruct views of the waterfront from all properties and roadways to the east, north, and south of the proposed building. The July 12th HDC decision represents a clear error of fact because it does not enforce existing law in that the proposed building violates Bristol's HDC guidelines, which require that the HDC, quote, safeguard the heritage of Bristol by preserving historic districts, unquote. Professor Hassanuddin Khan stated that the, quote, proposed structure would seriously impair the historic and architectural value of the surrounding structures and surrounding area, unquote. The July 12th HDC decision represents a clear error of fact because the proposed building violates the Secretary of the Interior Standards numbers 1, 8, and 9. I personally analyzed the past 5 years of decisions made by the Bristol Historic District Commission, and I made a 10-page listing of selected cases that demonstrate the HDC's track record of enforcing the Secretary of the Interior Standards and the HDC guidelines for all proposed new construction and changes to existing buildings in the historic district. Every HDC decision concludes with the statement, quote, findings of facts includes that this decision conforms to the Secretary of the Interior Standards, unquote. Yet their July 12th decision represents a clear error of fact because it does not conform to the Secretary of the Interior Standards numbers 1, 8, and 9. The standard for rehabilitation number 9, which, according to the National Trust for Historic Preservation guidance on regulating new construction in historic districts, applies to all freestanding new construction, and it states in part, quote, the new work shall be compatible with the massing, size, scale, and architectural features to protect the historic integrity of the property and its environment, unquote. Carrying out this federal standard, the HDC guidelines require that the Commission ensure that, quote, the relationship between the horizontal and vertical thrust of the structure should be designed in the context of the historic buildings in the immediate vicinity of the site, unquote. An analysis made by Steve DeLeo of 24 buildings surrounding the proposed project calculated the average building height in the area to be 29 feet, and the measure an average of 36 feet across. A building that rises to 52 feet, as the proposed project does, clearly is not compatible with buildings that average 29 feet high. And a building that stretches 176 feet along Thames Street is clearly not compatible with an average 36-foot width for the 24 surrounding buildings. And no reference to Robin Rugg or Stone Harbor is allowable, since those buildings are not within the defined waterfront historic district. Professor Khan found that the, quote, proposed structure is dramatically larger in scale compared to the surrounding buildings. Moreover, the proposed structure presents a mass that is inappropriate for the area and will dominate and diminish the character of the surrounding buildings. This will result in a denigration of the historic character of the area, unquote. In its decision, the HDC inappropriately and unlawfully relies on the size of a building that no longer exists, the DeWolf Hotel, and that was constructed decades before the adoption of land use regulations in the town of Bristol as the basis for its approval. This is a tortured and unacceptable basis for breaking its own guidelines. The July 12th HDC decision represents a clear error of fact because the overall weight of evidence as supplied by the experts in the field of historic architectural preservation called for denial of the project. The applicant produced no competent evidence from experts in the field of historic preservation. Of the 5 professionals testifying in favor of the Belvedere-at-Thames project, an architect, a municipal planner, a real estate appraiser, a real estate agent, and a civil engineer, not a single one of them held a single historic preservation credential or its equivalents. Not a single one of them mentioned or spoke to the issues raised by the Historic District Commission guidelines or the Secretary of the Interior standards. In fact, the master plan drawings submitted by the architectural firm Union Studio were grossly misleading in that they graphically misrepresented the massive dominance of the proposed project over the surrounding historic buildings by falsely inflating the size of the adjacent historic buildings by over 50%. The July 12th HDC decision represents a clear error of fact in that they ignored and largely failed to consider the many issues forcefully raised by 7 expert witnesses, all of whom hold nationally recognized credentials in the fields of historic preservation, architectural history, conservancy, historic preservation law, and community redevelopment. Together, these 7 experts in historic preservation represent a total of more than 188 years of experience in the field. They presented multiple arguments that the proposed project is in violation of Bristol's comprehensive plan, historic district guidelines, and Secretary of the Interior standards. Key objections also highlighted that the entire historic district is threatened by the mass and scale of this project, that the project will overwhelm all the small-scale buildings around it, that the project is unfriendly to pedestrians, that the project is precedent-setting, and that, as an economic driver, the project would detract from the character of the area you are trying to draw people into. In conclusion, the errors of fact and the ignorance of the weight of evidence by both the HDC and the Planning Board all relate to a fundamental error on the part of those in favor of the proposed project, which is to believe that all economic development is good economic development. Development that destroys the very historic assets and environment that Bristol is relying on to draw in tourists is short-sighted. Worse, it is self-destructive. And it is irreversible. Once we have allowed our irreplaceable...
I object. May I be heard?
I am almost finished. I have 8 more lines.
Let her finish first.
Once we have allowed our irreplaceable historic assets to be torn down, as were the buildings on the lot where the Belvedere-at-Thames project is proposed, they cannot be brought back. Once a string of oversized boutique hotels and condos has been shoehorned into the small-scale historic district, they cannot be wished away in favor of more appropriately sized buildings. There are good ways to build in historic districts, but ignoring our own HDC guidelines and comprehensive plans is exactly the wrong way to achieve economic development that will go beyond benefiting the developer to benefit Bristol. Thank you very much.
Thank you, Ed.
Do you have any questions?
For the benefit of the chair, for future oncoming discussions, I would suggest that the future discussions be limited to something new. We've heard arguments, and I think we let her go on quite a long time. It would be my suggestion, and there are several points where she was well beyond what I think the appeal standard is in this case. I would simply suggest that future comments not repeat what we've already heard from several attorneys and the speaker who was just there.
I want to, before we continue, Mr. Scarshi, does the reporter need a break? I'm sorry. 5-minute break? Okay, we're going to adjourn for 5 minutes for the reporter to take a break.
Something new would be great.
Good evening, my name is Keith Maloney. I live at 72 Griswold Avenue in Bristol. If you give me a minute to get to it, I will give you something new. I observed all of the meetings, and I was terribly disappointed by the conduct of the town solicitor. Someone who...
Time out. This is not an element of the appeal.
I understand that.
And therefore it's not a subject for your comment at this point.
Well, let me just say...
Are you in a butter with an interest in this matter?
No. I have a comment to respond to Mr. Cogan's question. It has to do with why the objective disagreement of the experts opposed to this project was not included into the decision. I think it was a very telling moment. I think Mr. Tights was absolutely speechless for the first time I've ever seen him. And then he had
I'll leave this to the chair, but this has nothing to do with the appeal.
Let me just make this statement. When he
I
was
tell you what's going to
challenged,
happen here. You don't tell me what's going to happen here, okay? That's how that
I'm
works.
asking you to let me make the statement.
Make it fabulous. If you have something new is good, you don't want to go through this all night long, so you have the same stuff.
The answer was...
I do think your argument, if that's what you're making, should be addressed to one of the standards of review. Clear error, prejudicial, procedural error, or against the weight of the evidence.
And I think it is procedural, and it specifically, I thought your question was very pertinent, and Mr. Tights' response was, after he couldn't speak, was that he found the expert testimony not credible. Now that's according to whom? Mr. Tights? Did they take a roll call vote of the 7 members of the Historic District Commission, and did they vote that that expert testimony was in fact not credible? Mr. Tights was leading the ring.
Just for the record, I'd like to know my objection as well to this witness. Thank you.
The second point of rule. No one has spoken to the fact that in the advertising, which was, again according to Mr. Tights, correct and timely, no one has noted the fact that the advertising of the buildings were not to scale. That the buildings adjacent to the proposed buildings were in fact presented in the Phoenix more than once at 1.5 times their actual size, which is obviously a clear intent to display.
I note to the chair that's nowhere on the appeal. This issue does not appear in the appeal.
It's a statement of fact.
And it's irrelevant.
It's a statement of fact.
It's a statement of fact that has no relevance to the appeal. But I will let the chair determine that.
So the advertising and notices have to do with giving the public notice of the pendency of proceedings before the boards. You're not saying, I believe, Mr. Maloney, that there was no advertising.
I'm saying that the advertising, and again quoting from Mr. Tights, provides persuasions.
I'm not sure,
not
sure that he said the advertising did that. I believe Mr. Tights' point was there are statutory obligations with regard to the giving of notice for different proceedings of the Planning Board and the Historic District Commission. And I believe Mr. Tights' argument was each board or commission met their statutory obligation to give notices to the public and to affectors within potential objectors within the distance. So they gave required notices.
It's the legal requirements.
Correct, yes. And that's what we would have to make a determination of, whether they made a procedural error.
I made my point and I appreciate your allowing me to make that. Something which I believe has not been addressed is that the justification for this project is about economic development. As the former chairman of the Bristol Economic Development Commission for 4 years, I'd like to ask the question, where's the proof that this is an economic benefit to the town?
That's
Not part of this also.
It's not clear error, that's not a prejudicial procedural error, and it's not something that's for or against the weight of the evidence. I understand those are considerations that presumably the planning board and the Historic District Commission should have taken into account, but that's not reviewable at this point for us.
It's hard to believe. It's the legal mumbo jumbo. Pardon me. I'm going to close with one statement. I think that this project with 15 variances is an example of corporatism. The corruption of public policy by special interests.
Okay, thank you.
Sacrificing the common good for the short-term objectives of particular businesses
Sir, you have
and
to stop.
developers. And I thank you very much.
Thank you.
Good evening. My name is Philip Marshall, and Philip has one L, and Marshall has two L's. And I am a resident of South Dartmouth, Massachusetts. I provided testimony for the record on May 8th, and had 40 years experience in the field of historic preservation and just retired from Roger Williams University after 27 years at the university as head of the...
I have a comment.
Yes.
We have somebody who testified in the proceeding, and now they're here trying to bolster their credibility. It's totally inappropriate.
Okay,
for this proceeding.
Excuse me.
He's not a resident. He is an expert who testified before and now wants to testify again, apparently, and it's not appropriate, and it could be prejudicial and could affect the status of this hearing. I would say not to this point, but I would be very cautious if I were the person making a statement here, that he should specifically address specifics that are on the record and go no further.
Thank you. I understand that. What I would like to do is read just a few comments that I wrote for the record on May 8th, which were not, which maintain that there's clear error and lack of support of the weight of the evidence.
Wait a minute.
Those items are in the record, Professor Marshall. So if they're in the record already, we don't need you to reiterate them.
Okay. At that point, I refer those to you because they were completely discounted along with other expert testimony during the July 12th letter. So I invite you to take a look at those as a matter of record, and thank you very much for your consideration.
Thank you, sir.
You're welcome.
Please note my objection again.
May I just be heard on just on that one issue?
Would you come up to the
Right.
mic?
Certainly, I'm not going to argue it, just a procedural point.
Steve McGillivray, if they do come up for public comment, they are allowed to point to the record and say what parts are ignored or weren't paid attention to, or they're allowed to argue from the record. I think that's correct, right?
That's exactly what I said, Mr. McGill.
Yeah, so I think the previous...
That's not what he was doing.
Well,
until we pointed it out to him.
Yeah, but then he got cut off again, and I think he was going to point to portions of the record that were not...
I couldn't take that risk of what he might have done, given the angle that he was taking, and I thought it appropriate to safeguard the rights of both parties, that he'd be, that he understood where he could go and where he couldn't.
That's fine. I just think it's not in the nature of public comment to cut people off like that and make evidentiary rulings.
I didn't cut anybody off. I was trying to preserve the nature of the proceeding such that the comments are appropriate and they don't taint this proceeding.
Okay, then I'll just my objection to that ruling on the town solicitor's part.
Thank you. Mr. Harrison?
May I add my comments on this objection?
Sure.
Well, sure. And I'll be very quick. I just support Mr. Shikarchi's objection. I think it's, and your solicitor's decision, it's even worse because Mr. Marshall did not testify. And it was May 10th, the transcript wasn't May 8th, but he didn't testify. It was Mr. McGilvery submitting his written statement and his resume. So it is on the record, it is there, it's an exhibit, but he didn't testify. So he's actually trying to take what was a written statement before and bootstrap it as testimony here. So I would support the objection. Thank you. Okay, Mr. Harrison.
My name is Halsey Harrisoff, and I live at 125 Hope Street in Bristol.
Spell your last name.
I'll spell it for you. Herresoff. I have to spell it all the time because nobody can pronounce it. I don't know of any issue that has been so vigorously considered and forth in this one, which has been going on for a very long period of time. And the reason that it's been so controversial is that it's a matter of very great importance for many of the reasons that have been articulated by those who spoke just before me. Going back to the years when I was very active in the Bristol process, we had a town solicitor, Frank Williams, who always spoke to me about the necessity to consider legality and equity. And by that, he meant that it's a matter to be decided, one where all the legal matters are taken care of, such as by these very eloquent lawyers, are all the I's dotted and all the T's crossed. Is it legal? The other part of it, the equity, is more the issue of what is right, what is best for the people of the town. And I would urge that this appeal board look not only at fine legal details, but look at the equity. Every day that I walk up to the post office on Hope Street, people stop me and they say, what about this? They know that there was a decision on July 12th, and between then and now, September 17th, is more than 2 months. But the issue is very much debated, very much open. And I appeal to you as the appeal board to consider the fact that not everybody in Bristol by any means is satisfied with the present status of this project. We citizens, we people who love Bristol, we need a further opportunity to get into this again. And I think it's a matter of such great importance that it would be correct for the appeal board to send this back down for further deliberation, so that we who love Bristol, we who attended that magnificent ceremony yesterday, the renaming of the post office, that we have a chance further to this to consider what's right for Bristol. And hopefully we don't have to knock the whole idea down, but I think it needs to be very much altered and fine-tuned, and I hope there'll be such an opportunity. Thank you.
So please note my objection as well.
Can we do this now?
I'm going to wait to see what you say. If you stay on when you're supposed to stay, I won't say a word.
Prompt? Sure. Okay. Okay. Tom Bergenholz. You know how to spell that, right? Bergenholtz, 366 Hope Street. So I'm trying to, I had a whole thing here, but a lot of it has been spoken about, so I'm really sensitive to you guys, so I don't want to do that, okay? But one of the things that I think we've missed here is the comprehensive plan that the town of Bristol has. And I've spent a lot of time going through this plan. It's about 180 pages, I think, if I recollect. It's a pretty good plan. But I think what the plan states is that the plan really is the blueprint and the framework for all future private and public development projects. So if you believe in the plan, then I think if it's a blueprint and framework for all these future private and public development projects, then I think we have to go by what the plan is telling us to do. And one of the things that hasn't been mentioned is there's a policy to ensure that the neighborhoods are livable places. And they say, well, how are we going to do that? So they have a policy to implement in the plan. And it's very specific. It's number K in the plan. And it's the only time in the plan that they use the word require. They say, in point K, it says, require that new developments stay within a scale that is appropriate to Bristol. Now, I don't know where this falls within the 3 parameters, Bruce, that you're talking about with, but in my opinion, that failed. The board, the HDC failed in this because it's allowing the height as well as the mass in this project to be passed on to the planning board, and then now it's in your lap. So I think that that word required, that new developments stay within a scale that is appropriate to Bristol, I think that anybody who can visually see what this project looks like, that is not the scale that is appropriate to Bristol. Thank you.
Thank you. For the record, I know my appeal as well. Way beyond. Damn. Objection, I make this thing. It's not my record. Objection for the record.
Would anyone else like to speak?
My name is Robert Jacobus, Jacobus, 35 Church Street. So I've written out a testimony here. I've been trying to adjust it in real time because I'm trying to remove things that aren't new and trying to figure out how to do that in real time. I have some errors of procedure that I've noted down, and some have been covered. Some have been covered adequately, so I'll try not to cover them again. I do want to cover the recusal issue. I heard counsel for the HDC claim that he knew nothing about the recusals, and I claim that he failed to advise those members who recused themselves of the proper procedure. There is a procedure to be followed for recusals, and the people...
I have to make a timeout here. That's nowhere in any of the appeal that's been filed by the appellant.
About recusals.
About Mr. Tights failing to advise somebody or advising somebody inappropriately or not advising them of certain procedures.
Okay, did the recusals appear in there? Can I speak about the recusals?
You can speak about the recusals because the recusals were referenced in the appeal.
They were referenced,
correct.
Okay. So the members who recused themselves did not follow the correct procedure, and the correct procedure is specified by the Rhode Island Ethics Commission website as being a person or entity subject to the Code of Ethics must write a letter to the Commission requesting an advisory opinion. The letter should contain complete statement of facts. You may write a paragraph or several pages depending on your particular circumstances. The Commission will adopt an advisory opinion and vote by at least 5 of 9 members, and you will receive a written copy. This opinion...
I hate to interrupt again. It's not an accurate statement of the law. Nobody has to file anything before they recuse themselves. Never, ever. Because why would you want to delay somebody's ability to make a proceeding more pure and more legal and more appropriate? Anybody can do that at any time just about. And what does have to happen, and you're correct, I think this is what you're referring to, what does have to happen is thereafter, they should be filing a written notice of recusal that is retained on record. But whether they ever filed that or not has really no bearing on the appeal. It has nothing to do with it.
All right.
And the recusal is on their own. If they recuse themselves, it's not up to somebody else to say, no, you can't recuse yourself.
I understand.
So it's not something that's either, what you've stated is not something that's either correct legally, and I don't want it to taint what's going on here by making accusations that aren't true. And I don't think it's any good for you, and it's not good for any of us. And whether they actually filed a written document later as to that, the fact that they recused themselves really has nothing to do with the appeal.
Okay, so the recusals, that I don't understand. All right. It's optional. What you're saying is it's optional to apply to the board, to the Ethics Commission. I think that's what you're saying.
You mean ahead of time?
Ahead of time.
It's optional. Somebody can recuse themselves without any other advice.
Yeah. Trying not to take up your time unnecessarily. Point 2 I made, planning board did not apply, sorry, wrong discussion. Point 3, HTC joint planning board committee meetings corrupted the process, and we've talked about that. I think the council for the appellants had a good discussion. The point that I wanted to raise was that independent decision-making required by the normal sequential flow of HDC to planning board was missing. This leads to a domination of one board over the other. The dominant personalities exert undue influence on the combined group. The normal required independent deliberations were lost for the duration of this process. A notable example of this interaction was when HDC member Mary Millard observed that the massive size of the building should be addressed. She said this in the meeting. This conversation was cut short by a curt directive by council that they should carry out an informal survey of both boards as to the probable votes. There was no meaningful discussion of the HDC historic preservation issues. It was cut off. The joint meeting format was chosen to streamline the process at the expense of proper consideration of the issues. One committee member observed the observation that joint meeting makes it easier to make a decision, end quote. Point 4 I made, the incorrect building height. We already heard that issue, incorrect building height. We had an expert witness who testified that the building height legally in Bristol includes elevator structure, stair enclosure, amenities deck, and should be 52 feet. HDC guidelines have the force of law. That I think I heard contradicted here in Bristol Code 14.4 C2. There is this statement: the Commission shall adopt the guidelines and rules of procedure necessary for governance, which shall not be inconsistent with the provisions of this chapter, state law, or the Secretary of Interior standards for rehabilitation or similar law. Commission guidelines and the rules of procedure will become part of this chapter, meaning the Bristol Code, after the approval by the Town Council. So the guidelines are not technically guidelines; they are the force of law. We talked about the HDC voted for non-existent future guidelines. That was included in the letter of decision. I think we've covered that one. There was no conversation in the meetings that indicated that they discussed the guidelines. So how did that get into the letter of decision? It's not support. There was no discussion about the guidelines, so that slipped in there without, I think, proper discussion. HTC voting on subjective criteria. In the joint meetings leading to the decision, HTC member comments most often voiced the opinion, "I like the pitched roof." That was from the HTC. All other criteria were ignored. In fact, the voting criteria should not be an opinion, but should be based on findings of fact. In other words, liking the pitched roof is an opinion. It is also inappropriate to focus on one criteria and ignore the general question in which the guidelines is specifically intends, does this building satisfy the requirements of the guidelines? The guidelines and expert preservationists want the building to fit into the neighborhood. The approved building should not be an extreme in the style or measurable characteristics. Objective criteria require scientific metrics that compare the proposed project with metrics of the neighborhood. In this case, special waterfront between Church and Bradford Streets. This was not done. There were no metrics cited anywhere, except perhaps one chart that you have already seen, and none in the discussions that I observed. And this, in fact, the HTC voted to permit a building that violates many of the norms of the neighborhood without finding a basis for this in the guidelines. So that's my testimony. Sorry it was a little choppy because I tried to edit it in real time. Thank you very much.
Thank you. Yes, sir.
No, my objection.
Good evening. Ben Bergenholtz, 385 High Street, Bristol. Last name B-E-R. I'm familiar with Ben, I imagine. So it's B-E-R-G-E-N-H-O-L-T-Z. I hold an undergraduate degree. I'm sorry? Oh, 385 High Street in Bristol. And I hold an undergraduate degree and master's degree in historic preservation from Roger Williams University. I'm an alumnus of the Abingham Trust Program in the United Kingdom, an alumnus of the Art Boutin Program in Paris, France. I attended education at Smithsonian.
I have an observation. Just to make clear, you're not here to testify.
Yeah.
We're not concerned with your qualifications if you're putting them down there for the purpose of testifying.
Okay.
And trying to taint the proceeding by add additional evidence. It's just not fair.
Okay.
It's not appropriate, and it's not. I'm sure if you had discussed with Mr. McGilvery that this was your intention in this kind of form, I don't think he would have encouraged you to do this. I'm sure he didn't. So what I would ask you to do is focus your argument so that the board, which has a big task here,
yes, I
they have to separate the wheat from the tare. So you've got to help them do that and focus on the issues that are part of the appeal.
Sure.
All right,
sure.
thank you.
I do, but in going to what I'm going to talk about here is I meet the Secretary of the Interior's standards for a historic preservation professional as well as architectural historian. And so when I did look at the procedural history and then the findings of fact, there was something that really stood out to me, and that was in general criteria, public views of the waterfront. It was found that the building is not going to block a lot of water views from as it is now. It also mentioned visible elevations, and the HDC finds that the design of the building has been judged from all elevations, and although there is much disagreement about the design, all elevations have been reviewed. I'm sorry, I'll slow down. You want me to repeat it? Although there is much disagreement about the design, all elevations have been reviewed. And I don't know how that's possible, because I don't remember seeing any type of site visit plans to the site. I don't know how people understand what 47 feet looks like. I know somebody had mentioned that it's 12 feet above the telephone poles. I don't know if Andy Tights went to Ace and bought a 50-foot measuring tape, but we've all been there trying to measure something up. The tape's just going to fall back down. I don't know how people realize how tall this is and then how that fits in with the scale of the buildings around it. It would be impossible for anybody to determine that without having some sense of where the 47-foot mark is with the buildings around it, and that's never happened. So when they say that they've reviewed this from all elevations and compared it to the buildings around it, how is that possible? I don't know what 47 feet looks like. And I certainly don't know what it looks like compared to the buildings around it. And that's it.
Thank you.
I don't my objection. He's testifying. There's no legal argument there. It's just testimony. Thank you.
Thank you.
I'm Brian Clark, 31 Evelyn Drive, and I'm actually going to attempt to speak to procedure here and not get on a tear. Thank you for volunteering your time tonight, as many of these boards do, and as I sit in a room full of my neighbors, we all have concerns. The meetings that were held over the summer, the joint meetings, and I want to speak to procedure here, okay, and I'll be as quick as I can. There were multiple interruptions of order for point of order references, and HDC did not have what I appear as a grasp on their procedural duty at the time. They were following the planning board's lead, and the solicitor, very important point, appeared to be running these meetings. Okay, and that's what I want to speak to as far as procedure goes. Okay, thank you.
Thank you.
Please know my objection again. There's no legal argument. Testimony.
That's not testimony.
Good evening. My name is Steve Katz. I live at 42 River Street. I am a member of the Bristol Planning Board. I was at all of the meetings for this project for the last several years. I will
Mr.
not...
Katz, you realize we're considering the HDC.
That is correct, and I'm speaking strictly to this HDC appeal, and only that appeal. And I will not discuss anything that has been previously discussed on either side. So hopefully Representative Shikarchi won't have anything against what I have to say.
He's going to object no matter what.
I'm sure he will. He gets paid to object.
Give him a fair shot.
Thank you, sir. So, what I want to talk about is why I got on the planning board and what we on zoning, on planning, on all the boards and commissions, what our responsibility is to the town of Bristol. And our responsibility is to balance the needs of the developers, or the requirements, or the desires of the developer with the needs and the desires and the requirements of the town. It's as simple as that. That is the job that I have on the planning board. That is the job that you folks have on the zoning board. That is the job that the HDC had in making this decision. I believe the HDC clearly erred in that decision. I believe that they failed to listen to what the majority of the town of Bristol has said time and time again with respect to the size of this project. I've talked to a lot of people. I have not found anybody that is against any building on that site, but against what's proposed.
Point of order to the
Yes,
chair.
sir.
I mean, this is, again, adding evidence. It's not in the record. It's not appropriate. It's clearly not appropriate.
So, Counselor, I understand. What I want to go to is how they made the decision. And again, I believe the HDC failed to take into account the needs of the town, the majority of the needs of the town of Bristol. Thank you.
Thank you. Mr. Spurgeon?
Yes, I will object. It's a procedural defect.
I got it.
Procedural objection. Good evening, everybody.
everybody. 3 lawyers walked into McGiller's Tavern, right? My name is Catherine Ziff. I live at 32 Z as in zebra, I, P as in Peter, F as in Frank. I live at 32 Greylock, Grey, L-O-C-K, Road. I am one of the 7 experts, and since it has been raised, I will speak only to my highest credential, which is a doctorate in architectural history. I found that comment extraordinarily offensive. That is not, however, what I want to say tonight. I am also the executive director of the Bristol Historical and Preservation Society. On March 7th, and my phone is so I can check my dates, March 7th, I believe it was in response to an article published in the Bristol Phoenix regarding Mr. Reuter's initial proposal, the peaked roof design. I initiated a conversation with the board of directors of the Bristol Historical and Preservation Society to ask if they wished to make a statement regarding the proposal. We discussed it via email and put forth a letter objecting to...
Is this in the record right now?
It will be. The letter,
No,
no,
it won't
sorry,
be.
the letter is, the ultimate letter that we came up with is indeed in the record.
I would ask the chair to continue your question as to whether she intends to keep things, speak of things that are already in the record.
Yes.
Or adding things to the record.
I am not adding things to the record. I want to
So what
speak
did you
about
mean when you said that it isn't, but it will be?
the letter that is in the record. I want to tell you the story of what came about the letter that is in the record.
That's, she had a chance to testify. She provided a letter. This is not appropriate.
The letter that we presented.
Stop, one at a time. Everybody sit down, and you can speak on what we are talking about.
The letter that I presented was a second draft regarding the flat roof design. When the HDC returned to the peaked roof design, it was a betrayal of it. It felt like a bait and switch, and we felt like we didn't get the opportunity to speak about the peaked roof design. So I am speaking about the letter that we wrote, but we revised the letter based on the revision in the plan. So when the HDC reverted back to an earlier plan, we were denied our right to speak to the merits, or lack thereof,
I've got to say, she's testifying. This is evidence.
I don't agree with you.
It's not part of the record.
Excuse me, I'm speaking right now. It seems to me what this commentator is arguing to has to do with the argument made by Mr. McGillivray that there was prejudicial procedural error where a plan was presented, objectors testified about it, and created a record about a flat roof plan, and then the boards reverted back to a peaked roof plan without reopening the record. That's an argument with respect to prejudicial procedural error. So with that, you can continue if that's your point,
that is
only that.
That is my point, and that is only my point. If there is further question about how our letter came to be, as well as a timeline for that, because the letter was revised in response to the timeline, I would be happy to answer those questions.
We don't have any questions. We understand your order.
All right, thank you.
Thank you. I would like to object very specifically. The application that was filed had both designs. They had both designs in it. I can't testify. I only give legal argument. I don't give testimony. I'm not sworn in.
Right. Mr. Sakarshi, I asked Mr. McGillivray if both plans were part of the record, and he said they were. I understand that. His argument was that the comment period for commentators was presented at a time when, at least his argument is, the boards were considering a flat roof plan, and that they then later reverted. That's his argument. I understand what his argument is. Ms. Ziff, or Dr. I think it's Dr. Ziff. Dr. Ziff, you know, her argument was along the same line. We understand the argument.
Thank you. Just please note my objection for the record.
Hi, my name's Mary Ann Bergenholtz, 366 Hope Street, Marianne Bergen, Holtz. The very first Historic District Commission meeting that was held on this, the Historic District Commission was not even aware that they had guidelines. I found the guidelines after that meeting when I was trying to figure out how any of the members could possibly think that this was appropriate. That meeting ended in 2 for, 2 against, and 1 who really wanted that a large part of the top of that building to be lowered. At that meeting, the developer's attorneys asked to combine the next meeting with the planning board. In the interim, I was doing research about how could this possibly happen. I found the guidelines, the 31-year-old guidelines, on the home page of the town website for the Historic District Commission. I brought those in, not wanting to embarrass the board by springing something on them that they weren't aware of. I sat on a board once myself. I was an elected official. I did the same kind of oversight that the planning board and the HDC is doing. And so I brought these guidelines to Diane Williamson in the planning department. She looked at them and she said, no one knows about these. And then I brought them to Susan Church with the HDC. And she said, no one knows about these. People have been sitting on this board for 30 years, not realizing what their own guidelines are.
I find that hard to believe, actually.
It's a fact. You can ask Diane Williamson. You can ask them.
Ms. Bergenholz, once you brought them to their attention, then they got considered during the proceedings? Is that what happened?
No, I want to address the 31 years in the findings in the decision, okay? I want to, I'm sorry, what was your question?
So, my understanding of what you alluded to is that members of the board may have been unaware of them, you became aware of them, you made the board cognizant of these guidelines were in existence, and then the proceedings addressed those guidelines. Is that correct?
No, the proceedings, according to the decision, at no time, and I went to all the meetings and I also looked at the transcriptions of the meetings. At no time did the Historic District Commission talk about how old the guidelines were and how they didn't need to go by them. There was no discussion. So I don't know how it says here that they noted. There was no one who discussed them noting that these guidelines were 31 years old and in need of changing. The other problem here is that it seems to me tonight, by Attorney Teitz's input, that, oh, they have a lot of stuff to go by, and that's just one of the things, and it's a small little part of a guideline that's 31 years old. The state law and local zoning and local ordinances state that every year when the new members are appointed, during their organizational meeting where they choose a chairperson, they are to look at the guidelines and see if they need to create the guidelines. They have had 31 years to change the guidelines. And so if they were well aware of them and they didn't want those guidelines to be applied to what goes on in that historic district, then they should have gone to those guidelines and looked that it specifically states only the small-scale buildings on Franklin, on State, on Bradford, on Church, and on John Street, that only those small-scale buildings could be included. They've had all this time to do it, and those are the specific things that it says in the guidelines. State law comes first. Local ordinances can be stricter than state law, and the guidelines can be stricter than what the ordinances originally said. But those ordinances have the power of, the guidelines are not just guidelines, as the attorney for Mr. Reuter has stated. They are actually added into the ordinances. They were not applied, and there was no place in the record that you will find any discussion about what the HDC feels about those guidelines. So if that came in to the decision, it certainly just came out of thin air. The other thing is to straighten out what was going on, and I think it was very unfair. The master plan is a master plan. It's not phase 3 of the Belvedere block. It's not phase 3 of the plan. On the master plan, it just says master plan for the Belvedere-at-Thames. All of a sudden, it started to creep in from the developers' experts that this was a phased development.
I think that's more to the planning board than it is to the HDC.
Sorry, that's true. But as far as the last point that I'll make on the HDC. The last point on the HDC is this. The plans were submitted, I believe, April 28th. That master plan was submitted April 28th. That plan did not have a pitched roof. That plan says all over it, not to scale. That plan includes other historic properties in the drawings that it actually says are not to scale. I believe that the Historic District Commission relied heavily on those plans and what it said and what the scale was to determine that it would fit the character of the neighborhood. And I think that that was an error. That's my testimony.
Thank you very much.
Thank you for listening.
No, you object, correct? Would anyone else like to speak?
On any matter, I guess, at this point. I think he started with supporting the appeal, and at this point, whatever.
Anybody who wants to speak in favor of the developer's views? I think we have to give rebuttal. Is that right?
Which one would you like to go first?
And I'll try to be very quick here, too. I know you all consider that an oxymoron for me, but particularly when I reach for more notes. I just want to hit a couple of items here. I just want to come back to the DeWolf Hotel. And just, I know I got sidetracked with the question of, no, I don't know how long it's been gone, other than it's been gone a long time. But I think the point was, again, I don't think, the HTC didn't say, oh, the DeWolf Hotel was here, therefore this hotel can be here. It wasn't that clear a connection and the sole basis for it. It was simply, as they were weighing all of these issues and trying to decide the question of what was appropriate for this area, part of it is the history and the historical stuff. And although it may be gone, it was in evidence before them with a large view of it, and it is part of the history of this part of downtown Bristol, just as much as are the mills which, quote, wall off the harbor. Whether we like them walling off the harbor or not, they're part of the history of Bristol. And the DeWolf Hotel, which was, as shown by this exhibit, of a scale similar, if not larger, to the proposed building, and on the waterfront side, blocking off the views of the waterfront completely, where the park is now, is part of the history of Bristol. So I don't think it was error to consider that as part of their decision. The other question, there was an item in the written appeal that never got addressed by anyone. I just want to mention it was alleged as error that the HDC improperly ignored the potential archaeological significance. And I just want to address that. I don't think there's really any question about that. In the record, there was the information that an archaeological disturbance assessment had been performed in connection with the expired approval, and it was done by the Public Archaeology Laboratory, which was a nonprofit organization, and they confirmed in writing, and this was submitted also at the hearings, that the remains associated with the Pierce Distillery site, which is what they were investigating there, are not expected to be present beyond the limits of the area. And also there was a letter from 2007 in the record from Edward F. Sanderson as Executive Director of the Rhode Island Historic Preservation and Heritage Commission and Deputy State Historic Preservation Officer, and he concluded in that letter, quote, "We have determined that field work has been satisfactorily completed, and therefore we have no objection to construction beginning in the Thames Street parcel." Well, I understand that was for an approval that was expired, but the underlying fact of a decision of the government officer given the authority to enforce it doesn't change over time, notwithstanding the fact that the actual approval expired, the underlying factual basis remains. Finally, there's been a couple of people raising questions about the scale of the elevations was wrong. And I'm not even going to begin to speak to what was ever advertised or in any way shown in the newspaper. The town of Bristol never published elevations in the newspaper. Developer did, objectors did. I'm not going to speak to that. As to the plans that were before the Historic District Commission, there was debate. It was raised, I believe, that certain people said they weren't to scale. I am not aware of anything in the record that indicates that an expert witness, someone, an engineer or surveyor or someone like that, came forward and said they're not to scale. There were a lot of lay people who said they were not to scale, and I know the HDC looked at it. And we're not in rural Maine looking at a site that's 2 hours away through the woods. We're looking at a site that's a 3-minute walk from here. And so the HDC members were familiar from their own observations of certainly the relative heights of all the existing buildings. So I don't think there's anything in the record to suggest that there's any error in that part. And then finally, I just want to note, so of my calculations, just of the 7 quote-unquote experts that were presented against it, 3 of them were not present. It was written only. Marshall, Kahn, and Statura were written materials that were presented on May 10th. 3 of them were there in person. One, Andragon on May 10th, And I am Church, I guess it's Church, I can't, Adam, TSCHIRCH was Church, was present on June 7th, and Catherine Ziff was present on June 7th, although I'll note that her credentials weren't admitted, her letter was, but I'm not going to argue with her position. She did say that she was executive director of the Bristol Historic Preservation and Historical Preservation Society. So I just want to note that but those were the three who were present that would appear to be the experts, not 8.
You said 4 were present, 3 were...
Well, there was also someone called, Mr. Papo was there, who spoke. He attempted to present himself as an expert with credentials for historic preservation, but he spoke to economics, so I don't know whether that's considered that. If you want to take a look at it, it was on his testimony starts on page 88 of the June 7th transcript. Unless you have any further questions, that's all I have. Thank you.
Thank you. We have that to come up.
Thank you very much, and thank you for your consideration tonight. I just go back to the beginning of this hearing, the standard of review to overturn a decision. You may have heard a lot of testimony tonight. Maybe I wouldn't have liked you to hear it, but you heard it anyway. That's your prerogative. But that is not the basis to overturn a decision. You need to find clear error of law or prejudicial. You may have said to yourself tonight, if I were on the Historic District Commission, I would have voted a different way. I would have asked that. What you had tonight was a lot of people who testified. Their comments were in the record. They want a second bite of the apple. They can't get it. It's not right. That's not what the law allows. They'll have their bite of the apple when this project comes back before the zoning board. That's their second bite of the apple. And then there's court actions. But for you to overturn that, you have to find that there was no evidence or not enough evidence. There was ample evidence. A lot of these people didn't like the outcome. So what do? We attack the board. They're not smart. They don't know what they were doing for 31 years. We attack the solicitor. I've known Andy Tights for 25 years. We have never, ever been on the same side of a case. We've always butt heads. We've done it respectfully, fairly. He's always been an honorable person. He served this town well. He doesn't deserve these comments that what was said about him tonight. That's not right. Just because you don't like the outcome, we attack the other side. We can't win on the facts, so let's attack the other side. Let's attack the program. You're charged tonight with a legal responsibility as defined in the general law. I ask you to listen to your solicitor and to review the state law regarding appeals before you cast your decision. I thank you for your consideration tonight, and thank you for putting up with me. Thank you.
Thank you.
I want to thank you also, Steve McGilvray, for the appellants. I want to thank you also for listening to us tonight. I'm not going to furnish my own credentials, but I did sit on a zoning board for some 14 years, so I feel your pain. I know what it's like, and I know it's very difficult, and sometimes you sit there and you don't know what to decide, and you do really try to make the best decision, so thank you. So I'll go hit just 5 points very quickly. I don't think, and I'll just hit this one very, very briefly. I don't think anybody's attacking the other side. We got a lot of concerned citizens here, very worried about it. I obviously can't go through the entire record, it's just too voluminous. So I'm going to focus on the decision and just point out to you, based upon what you heard, what both sides have admitted is in the record, why you should sustain the appeal. Firstly, we were told over and over again that there's no such thing as a precedent. Each case is on its own. You have to pay attention to just the facts of that case. In fact, in the decision on page 5, it says the HDC also finds it must judge this project on its own merits without regard for whether the Commission's decision will set a precedent. Fine. But then you go to what they actually looked at. And paragraph E says, the proposed construction will be compatible with the massing, proportion, scale, and size, and the spatial relationship of the surrounding environment because the construction reflects the historic and architectural history of the area. That's just a bald statement of recitation. It's not tagged to any actual evidence in the record. They then say, the HDC notes that it previously approved a project of similar density, size, and height over a decade ago. If that's one of their considerations, that's error. Because they're telling everybody, precedent doesn't matter. We handle each case on its own. And then they go ahead and in their very own decision they say, we don't have a lot of to support this finding, but the one thing we do have, the one thing that's of note that we're going to put down is that we did this before. That's error. Now, the other point here, when you come to, and people have talked about this before, but I just want to emphasize it because I think it deserves emphasis. The guidelines. Everybody admits that they have to follow the guidelines, but there's no real serious discussion of the guidelines in the decision. We all have admitted that the experts talked about the guidelines. We've had people come up here and reiterate what the guidelines say. For the HDC to denigrate the guidelines by noting that they're 31 years old and in need of updating, that's beyond their power. Either they update them and follow them, or they don't update them and follow them. Right? One of the attorneys noted that the zoning ordinances are going to change in March. Do you get to start ignoring the zoning ordinances now? Hey, they're going to be changed in several months. These are awfully old. We can do what we want now. No, you have to follow the ordinance. You have to, as a body, you have to follow the rules that govern you. And for them to state that is outrageous, and it shows that they relied on impermissible factors in making their decision. Now, let's get down to a lot of this was about the scale and also the historic nature of this area. And that was really the meat of both kind of emotionally and legally. People didn't like it because it was too big, and the experts didn't like it because it was too big and therefore not historic. So let's go to the decision again and see how the HDC handled this issue. Remember, we have 6 or 7 experts on one side, and we have an architect who doesn't have any historic preservation expertise on the other side. Do they go back and forth and say, this one's not credible, this one is, we weighed the evidence? No. They say, scale, this is paragraph 3, under general criteria. The HDC acknowledges that the proposed building is larger than the smaller buildings facing it across Thames Street and adjoining it immediately to the south. So they admit up front, this thing's out of whack. But they consider a couple things. However, when taken in the broader context of the block within which it sits, which used to be called Falugo Block, I don't think that has any particular relevance to the standards. And as part of the overall Belvedere project. What does that mean? We approved 2 parts and now we got to approve the 3rd? I thought there were no precedents. What do you mean as part of the overall project? Everything's considered on its own, right? That's what we've been told. So what do you mean we think the scale's fine as a matter of the overall project? So they say, as part of the overall Belvedere project, the HDC finds that the scale is appropriate. That's not a permissible standard. You know, oh, this guy built 3 buildings, wants to build 1 more, therefore it's okay. That's not how it works. In addition, the HDC, so this is the other thing that they consider, not the 6 or 7 experts that came before them. The other thing they consider when it comes to scale is the HDC has looked at the historical context of the old DeWolf Hotel. I know we've been over this, but I'm going to just tell you one more thing about it. Although located west of Hope Street and destroyed several decades ago. DeWolf Hotel, as it turns out, and there was evidence or testimony of this, was destroyed in the 1938 hurricane. So the DeWolf Hotel ceased to be, as a building, 50 years before the HDC came into being. A half a century. So you got guidelines that talk about existing buildings, okay? It's supposed to be, it says, Article 3, I'll paraphrase it, the buildings are small in this area, and the small scale shall be respected. Do they go and look at the witnesses and say, oh, this witness said the small scale is not being respected, but we don't find them credible, so we're going to go with this witness? No. They go to the DeWolf Hotel. It hasn't been there for 50 years. That's clearly impermissible. Before the rules were even written. 50 years before the rules came written. I mean, that opens up. That's one of those things where the exception will eat the rule. If you can think of everything that's ever happened in this town and use it as a measuring stick for something you want to happen, then you might as well throw the guidelines out the window. So that's an impermissible, and I think it's very clear, that's an impermissible factor to be considered when you're applying those guidelines.
Looks like that was Rhode Island directions. Go past where all maps used to be.
Exactly, yes. Well, we can tell you, the historic district, if this happens, the historic will be where the DeWolf Hotel used to be. There will be no historic district commission, or historic district. So, what you have, really, is you have a decision here. You got to look at the weight of the evidence. The key things here are scale and mass and size and whether it has historic character. And by their own decision, which is a boiling down of what they considered, written by Mr. Pites, who sits here today, by their very own decision, they didn't weigh the evidence. And there's a lot of other procedural problems, but they didn't weigh the evidence. And when they did weigh the evidence, they did it improperly. And they considered things they shouldn't have. And that's how they came up with this result. And that's why you got to send it back to them and say, guys, just do it the right way so we don't have to go to Superior Court and find out then that you did it the wrong way. Go back and do your homework. Thank you.
So I don't think we should be making an oral decision now. I think we probably need an opportunity to review the record in light of the arguments that have been made. We also don't appear to have time to start the other appeal. So that's going to need to be scheduled at some other time. Would that be correct?
Yes. We have a meeting next Thursday, the 27th, that has a pretty hefty agenda. And we have a meeting 2 weeks from tonight, October 1st, which has, excuse me, only 3 applications on it. So there may be time that evening to either make this decision and/or hear the planning board's decision. I think the attorneys in the room, if I'm not mistaken, all have sort of October 1st at the back of their head. We did get 3 applications that I advertised for that night. So we could either hear the regular applications first or make this decision that night.
So those 3
schedule another special meeting.
Excuse me. Those 3 applications are not an application for variances filed by this developer, are they?
No.
So they're normal.
They're regular applications. One of them would be a little bit like me.
pretty likely that the appeal of the planning board is likely to be lengthy, perhaps as lengthy as this one was. So maybe we need another separate meeting for the next continuation of the HDC appeal, which I think would involve discussion among the board members, perhaps a decision, at least an oral decision, and then the beginning of the planning board appeal. So that sounds like a separate night to me.
I think you're right. We're going to have to change some time out for this.
I think you should, yes, right now. So we have to find a date.
Well, we have to continue this to a date certain, so.
If we continue to October 1st, I'm just throwing this out there, if we continue to October 1st, we could make this decision hopefully that evening. And maybe 2 weeks between now and October 1st, with the attorneys and the board members, we could come up with a follow-up meeting date that works for everybody and announce it the night of October 1st, as long as it's 48 hours.
To the planning board.
Yeah. I'm sorry.
Sure. I'm just a little confused. What's going to happen October 1st, Mr. Chairman?
October 1st,
Who's going to release the decision?
We'll discuss it and try and come to a decision, right?
I don't know.
Yeah, that's the plan.
And then you have another hearing for the planning board, because you have 3, and one will probably be long, regular zoning hearings. Do they have to be on Mondays, or can they be at a different night?
We can make whatever we know, we can get enough people on the board to set the board.
For a decision, yes.
A typical zoning board night, with only 3 hearings, you should be done about 8:30. So I mean, you still have time to do some of this October 1st, is all I'm saying. So that might be.
So if we,
otherwise, if you want to try to pick another date.
no, but if we were to continue the HDC appeal to October 1st for purposes of discussion and perhaps conclusion to that, and then did not start the planning board appeal that night, would we have to re-advertise the appeal of the planning board decision?
As long as you announce it to a date certain that evening. So if you continue both of them to October 1st, see how far you get the night of October 1st.
I think it's unlikely that we're going to get to start the planning board decision on October 1st, so I think we ought to pick, if we can, a date certain for the planning board to be continued to after October 1st. If we can.
The 8th is Columbus Day, so we could do the 15th. We're looking at Mondays. Mondays seem to work well for this board. That's why it's, the 15th or the 22nd is like 22nd works.
Are there conflicts for council on any of those nights?
Monday. We're looking at Monday the 15th is my understanding?
That's a possibility. Does that work?
I'm available. Is that seats available?
I have a hearing on October 1st. You're just going to do the initial decision. I don't have to be here. I'm going to put that Hopkins decision made. That case may boil over to the 15th.
So we should do the 15th.
Can we do the 16th? 17th or 18th?
16th works.
Days better than me.
The town hall calendar? All right, well,
The 16th doesn't work for me, but the 17th could. Doesn't work for me.
Monday the 22nd?
I can do the 22nd. I can do the 22nd.
22nd is okay with me.
about the 18th?
18th works.
Thursday, the 18th. Oh, is that okay for you?
Okay for me. I will be away.
Okay. Doesn't work.
So we do October 1st, 2nd,
The 3rd of October.
2nd, 3rd.
Well, the 3rd of October is a council meeting, so you can't do that.
You're gonna need some time after the first meeting, something of break.
Right, if you're gonna decide on the
Make sure
first,
everybody's happy.
Mark needs time to write it up.
We already say the 17th?
17th didn't work for our solicitor.
16th or 18th.
23rd?
I agree with you.
16th, did we get the 16th?
I can't do this.
23rd, 24th, or 17th?
23rd, 24th.
I've cleared my calendar next 4 months. Then just tell me your
October 23rd, 24th?
Well, somebody was away the 20th to something.
27th.
To the 27th. So that week is out. This is first, you can't. About the 30th.
Yeah. Well, our next regular meeting is November 5th.
I know, but the 30th, we don't, that's a Tuesday. Yeah, I have something down on the 29th, is that right?
Is the first week of October possible?
No, we don't have a meeting. We have one September 27th.
Decision. You do, actually, you do have a zoning board meeting now, 29th of October. I think you moved that in to avoid the, because of the election coming in November. You don't have a meeting in early November. Yep.
This is the first date that I can't do. I've said yes to every other one.
29th.
I did not know that.
Well, how about the 30th? The 30th, I mean, the advantage is the 30th is the 5th Tuesday of the month, so it doesn't conflict with any of the regular meetings.
we can have a Halloween party.
There you go.
I don't think this is on the record, all of this is.
What's the 29th?
Yes, 18th.
Yeah, 16th. The 29th? You said no, I can't do the 29th.
All right, so the 30th. And maybe we just, if the 30th works for everybody,
We'll just change it to the 30th.
well, why don't you leave the 29th and the 30th there, depending on how many regular applications you have. And if you don't have that many regular applications, we can consolidate them to the 30th.
If the 30th is the planning board appeal, I don't think we want to put other things on that.
So then leave your regular meeting on the 29th and the 30th for the planning board.
Or push any new applications to the November, oh, there is no November.
Yeah, that's the problem.
So October 30th?
October 30th, and we have the 29th for regular application.
And so my question is this HDC appeal that we're continuing tonight going to October 1st, or are they both going?
The HDC appeal is going to October 1st.
Okay.
The planning board appeal is going to October 30th.
Excellent.
27th, we have a meeting on the 1st, we have a meeting 1st of October, the 29th, and the 30th. Is that correct?
Yes, sir. You know, the regular October 29th meeting, we could always bring it out. But the Veterans Day, election, so it would be late November, so you can get into Thanksgiving. So yeah, that's why we could, I tried to move it back.
You gave a motion to adjourn?
Second.
Somebody's got to make a motion.
Oh, yeah. I'm going to move that we continue the appeal of the Historic District Commission decision to Monday, October 1st.
Second.
All in favor?
Aye.
Opposed?
That's been continued to October 1st. I'm going to move that we continue the appeal of the Planning Board decision to Tuesday, October 30th.
Second.
All in favor?
Aye.
Okay.
Now, Charlie.
Just make a motion to adjourn. Second.
All in favor?
Aye.
Okay, thank you, everyone.